Good morning, everyone. Let's get started. Welcome to the Joint Judiciary Committee meeting, the final one of the interim. And so, Marissa, would you please take roll?
Good morning, Mr. Chairman. This is roll call for the Joint Judiciary Committee for November 7th. Senator Case. Senator Cooper.
Here.
Senator Furphy.
Here.
Senator Schuler. Representative Chestek.
Here.
Representative Crago.
Here.
Representative Haroldson.
Here.
Representative Jennings. Representative Nemec.
Here.
Representative Oakley. Here. Representative Provenza. Here. Representative Rodriguez-Williams. Co-Chairman Washit.
Here.
Chairman Landon.
I'm here.
All are present, Mr. Chairman.
Committee, I would entertain a motion for the approval of the minutes. Moved by Senator Cooper. Do I have a second? Seconded by Senator Schuler. All in favor of the motion, please say aye.
Aye.
Any opposed, no? Okay, the minutes are approved. Just a brief statement. We've been together many times, those of us on this committee and in the room, but I would remind, as one of our fellow co-chairs likes to say, be nice or leave. That's the decorum that we expect in our meetings, and we like to conduct things in a very professional way, and I know that everybody will do that. So, comments before we get started, Mr. Co-Chairman?
Thank you, Mr. Co-Chairman. It just amazes me how fast the interim flies by. You know, it just doesn't seem like it's a blink ago that we were meeting for the first time to get working for this interim, and the time goes by so fast. And I just want to take a moment to say thank you to our staff, our LSO folks. You know, we asked for so many bill drafts and memorandum and research, and they never fail us. And I just, as we're wrapping up this session, I just want to extend a huge thank you to our LSO staff that make this committee possible.
Yeah.
And on that line, I think most of us know that Katie Adams, who worked with us for a long time, has left employment with the LSO and has come to work, I believe, for Judge Reams here in Casper. Is that right? So we wish her well in her new endeavors, but boy, we'll miss her, right?
Yeah, we sure will. Mr. Co-Chairman, thank you for that. And we welcome having her in this community, but we're going to miss her on the LSO staff. And I would echo thanks to all of you who have helped us get ready for this meeting and all throughout the interim. Committee, we've got, I think, some good bills for consideration today. The agenda is not as jam-packed as we sometimes find in the judiciary realm, but I think we've got some good policy considerations, and I look forward to the work. So let's jump right in. Let's take up housing and unauthorized occupants. And just a brief statement or two, and maybe the co-chairman and others on the working group would like to weigh in, but appreciated a handful who agreed to kind of meet and see what we could do to make any further recommendations, particularly on 002, the residential property removal of unlawful occupant bill. We met, and we'll have a couple of thoughts to share as we work the bill a little bit later this morning. Mr. Co-Chairman, any thoughts about that effort or the bill itself?
Thank you, Mr. Co-Chair. I find it interesting, the divergent thought on this topic. You know, we hear from some who say the existing trespass statute works most of the time for most of the circumstances, and we hear others to say, no, we need some changes. And so it's interesting as we hear these different opinions about what the law needs to be in order to achieve the goal that we're looking for here. And I think as the discussion unfolds, we'll hear some different ideas and blend those together and maybe come up with something useful.
I think so, and really appreciated Representative Crago, Representative Oakley, Representative Nemec. Those all three sat in. I think others have had some input along the way on this bill. I like the fact that we have considered, and I think that Representative Provenza was involved too. I like that we're considering this effort because, Wyoming is a property state. And so very appropriate that we'll have a conversation. Brian, would you like to represent the work that you've done to get this bill ready?
Sure,
Maybe
Mr.
walk
Chairman.
us through.
Yeah. So, Mr. Chairman, I'll go through the bill. I'll highlight the changes or the discussion points that the working group highlighted for further consideration. So this is 25 LSO 0002. You should have draft 0.7. If you're working off the online copy, that's been updated. If you're working off a paper copy, that's in the packet that was left on each of your seats. So the version that was in the sent meeting materials is an old version. So it's 0.7 now. That's 2-01 in the online materials.
Thank you for that clarification, Brian, and that will represent a couple of things that the working group did to clean up and suggest for your consideration today, committee. So go ahead, Brian.
Yep. So, Mr. Chairman, this bill draft would authorize property owners to seek law enforcement assistance for removing unauthorized occupants from the residential property that they own. The draft specifies fees and liability or lack thereof associated with law enforcement's removal of an unauthorized occupant. The draft also prohibits the use of false documents that are property related and amends the offense of property destruction to account for unauthorized occupants. So starting on page 2 are definitions. And what I would note, particularly page 2, line 13, is a definition of residential dwelling. So this bill draft is limited to the removal of unauthorized occupants from residential property. Then moving on to page 3, the first kind of comment or note for the committee's consideration is that the working group discussed whether other law enforcement officers, whether other peace officers, i.e. municipal law enforcement, should be authorized or specified in the bill draft as being able to remove an unauthorized occupant. This was based on legislation from another state that focus on the sheriff being the law enforcement officer in charge or authorized to remove an unauthorized occupant. So page 3, line 16, an owner or the owner's agent may request from the sheriff in the county where the residential property is located the immediate removal of any person who unlawfully occupies or possesses the owner's residential dwelling if all of the following are met. And this starts on page 3, line 22. So first, the person requesting the removal must be the owner or the agent. Second, the unauthorized person for whom removal has been requested has unlawfully entered and remains or continues to reside in the owner's residential dwelling. Third, the owner or agent has directed, either in person or in writing, the unauthorized person to leave or vacate the residential dwelling. And that paragraph on page 4, line 1, the working group highlighted as another point of discussion, whether that paragraph should be removed entirely, whether it should be amended in terms of what that notice to the unauthorized person should look like, or whether it should be even required at all before that law enforcement assistance is provided. Then page 4, line 19, there's no pending litigation related to the residential dwelling between the owner and any known unauthorized person. Then, Mr. Chairman, the next paragraphs that begin on page 5 are additions that the working group directed. So these were not in the version of the bill draft that the committee looked at in September. So starting on page 5, line 2, these are additional conditions that must be met before removal may take place. So the residential dwelling was not open to members of the public through permission by the owner at the time the unauthorized person entered the residential dwelling. Then line 7, the unauthorized person is not a current or former tenant pursuant to a written or oral rental or lease agreement authorized by the owner or the agent. And then finally, the unauthorized person is not an immediate family member of the owner. And back on the bottom of page 4 is a staff comment just noting that the committee may wish to consider whether a definition of immediate family member is necessary for this article to specify who is and is not an immediate family member.
So Brian, on that count, I think we reference elsewhere in statute, perhaps, immediate family. What's your thoughts on that?
So, Mr. Chairman, in several places in statute, immediate family member is defined slightly differently sometimes. I put an example from a statute where it's simply defined as spouse, child, or parent. Sometimes it extends beyond that, but I think that's up to the committee to decide if that term needs defined, what that definition should be.
Okay, thank you.
Then, Mr. Chairman, page 5, line 15, to request the immediate removal of an unauthorized person who's occupying a residential dwelling, the owner or the agent must submit a complaint to the sheriff, and the complaint must include, at a minimum, and then many of these are similar to those conditions that I've already walked through. So on page 6, line 1, the person requesting it, filing the complaint is the owner or the agent, the date on which the residential dwelling was purchased by the owner, an unauthorized person has unlawfully entered and is remaining or residing unlawfully in the residential dwelling. The owner or the agent has directed the unauthorized person to leave, but has not done so. The unauthorized person sought to be removed is not an owner or co-owner of the dwelling and hasn't been listed on the title of the property unless that person has engaged in fraud. There's no litigation related to the property that is pending. And then on page 7, line 2, similar to before, these 3 paragraphs are additions that were not in the previous bill draft, and the same 3 concepts that I've already discussed. So not open to the public, then line 7, not a current or former tenant under a written or oral lease agreement, and then not an immediate family member. Then page 7, line 15, the owner must acknowledge that an unauthorized person removed from the property may bring a cause of action against the owner for any false statements in the complaint or for wrongfully using this procedure to remove that person. And as a result, the owner could be held liable for damages, penalties, and fees associated with that wrongful removal. Then page 8, line 1, the owner is requesting the sheriff to immediately remove the unauthorized person. Line 5, a copy of valid ID. And then finally, page 8, line 10, and this was a point of discussion as well, that the information in the complaint is true and correct and submitted under penalty of perjury. Then page 8, line 14, upon receiving a complaint, the sheriff is required to verify that the person is the record owner of the residential dwelling or the authorized agent of the owner, and that the person's entitled to relief. The staff comment on the bottom of 8 and the top of 9. So on the top of page 9, the working group suggested adding a sentence to the end of C. That would basically spell out that if the sheriff is unable to verify that the person who submitted the complaint is the owner of the dwelling, then the sheriff has no obligation to serve notice and vacate the residential dwelling. Page 9, line 10, after verification of the owner or the agent under subsection C, the sheriff shall, without delay, serve a notice to immediately vacate on all unauthorized persons and put the owner in possession of the residential dwelling. Line 14 spells out how service can be accomplished, either by hand delivery or posting the notice. The sheriff must attempt to identify all of the persons who are occupying that residential dwelling and document that on the return of service. And then if appropriate, the sheriff may arrest any person for trespass, warrants, or any other legal cause. Then page 10 is another staff comment, and this was at the direction of the co-chairman to consider breaking up that removal process into kind of 2 parts. So the first part, and this is page 10, line 7, would require, when the notice is served, it would be a notice to vacate within 72 hours. So it would give a 72-hour period. And then after that 72 hours, this is page 10, line 26, if the person hasn't left or if there's no court order that enjoins or prohibits removal, the sheriff shall, without delay, put the owner in possession of the property. And if the committee went with an approach like this where it's split up, there would need to be a few conforming amendments in the bill draft. Page 11, line 4, spells out that the sheriff's entitled to the same fee for service of process as specified in the sheriff statutes. $50 for the first 3 times is that statutory reference to 183608A. Then page 11, line 7, after the sheriff serves notice to vacate, the owner or the agent may request the sheriff to keep the peace while the owner changes the locks and removes any personal property of the unauthorized occupant. And when a request is made for that assistance, the sheriff may charge a reasonable hourly rate that the owner must pay. Page 11, line 17, specifies that the sheriff and his deputies are not liable to the unauthorized occupant or any other party for the loss, destruction, or damage of property that's removed. The owner or the agent shall not be liable to an unauthorized person for any loss, destruction, or damage to any removed property unless the removal was wrongful or unless the property is wantonly destroyed or damaged. Page 12, line 4 provides a cause of action for a person for wrongful removal from a dwelling. And a person who's harmed by a wrongful removal under this article may be restored to possession of the residential property and may recover actual costs, statutory damages that are triple, court costs, and reasonable attorney fees. Then page 12, line 19 specifies that nothing in the article is construed to limit an owner's rights, the authority of the sheriff to arrest any unauthorized person for trespassing, vandalism, theft, or any other criminal offense, and then any other remedies available under law. And Title I, Chapter 21 is primarily the forcible entry and detainer statutes. Then page 13, line 9 creates a new offense. And the first part on page 13, line 13, provides that any person who, with the intent to detain or remain on real property or in a residential dwelling, who knowingly presents to another person a false document purporting to be a valid lease, deed, or other instrument of conveyance, is guilty of a misdemeanor with a standard misdemeanor penalty of 6 months, $750 fine, or both. Page 13, line 22 is another offense. So any person who lists or advertises real property for sale, knowing that the seller has no legal title or authority to sell the property, or who rents or leases to another person, knowing that that person has no lawful ownership or interest, is guilty of a felony, punishable by 2 years, up to a $5,000 fine, or both. Then on page 14 is an amendment to current statute 63201, which is property destruction. Line 16 is a conforming amendment, and then on page 15, line 1 would provide a new penalty for property destruction. So it'd be a felony punishable by up to 10 years imprisonment, a fine of up to $10,000, or both, if the person unlawfully detains, occupies, or trespasses the property and knowingly defaces, injures, or destroys that property, regardless of the cost of restoring the injured property or the value of the property if destroyed. So the current offense for property destruction splits between a misdemeanor and a felony depending on the monetary value of the damage caused. What this would do is if you are unlawfully trespassing or occupying property and destroy property, it's a felony regardless of the value of restoring the property or the value of the damage. This would be effective July 1, 2025. With that, Mr. Chairman, happy to answer questions.
Brian, thank you for that rundown and all your work on the bill. Committee, a lot of considerations. Any questions? Questions from the committee of Brian? Go ahead, Mr. Co-Chairman.
Thank you, Mr. Co-Chairman. Brian, with regards to this language about the property not being open to the public, one, I'm assuming that has to do with the trespass, the unlawful entry into the property or so forth. But it seems to me that especially if you have an absentee landlord or a tenant who invites unauthorized people into the property, does that make the property open? I'm just trying to figure out how this is going to work in practice.
So, Mr. Chairman, Chairman Washut, and this is, for the language, page 5, line 2 is one place in the bill. It has to be permission from the owner at the time of entry. So if some other person beyond the owner, say another unauthorized occupant, purportedly opens that dwelling up for permission, that would not, I don't think that would qualify as being, against that paragraph. So in other words, it's only if the owner, him or herself, has held that property open to the public for some reason, whether it's, something like, simple as an event or, a multi-person type of, arrangement, hostile, something where you're holding, giving permission for entry. If the owner's not doing that, then there would be, I don't think there'd be a problem under this paragraph.
Follow up, Mr. Co-Chairman?
So what would the consequence be if we took that language out? Would it make the trespass unenforceable?
Brian, go ahead.
So Mr. Chairman, if that's removed, then the consequence would be when the owner is seeking an unauthorized occupant, there would be no distinction to whether that owner or agent held the property open to the public. So that's all that would do for purposes of this removal process. It would not, I don't know if that would have any impact on, how law enforcement may investigate or give notice for purposes of a criminal trespass.
Further questions? Anything else, committee? Okay, I want to go to testimony on this bill, and just as a reminder, committee, this came to us from a fellow senator who asked that our committee consider taking it up, and we had a good conversation about the bill in our second meeting, and it was the feeling of the committee to push it to this meeting for consideration. And so I think it's appropriate that we're doing so, and we would entertain any testimony on 002 Working Draft Point 7. Would anyone like to come forward and visit with us about this bill? I thought maybe the sheriffs and chiefs would be here. Good morning.
Good morning, Mr. Chairman. My name is Alan Thompson. I'm the Executive Director of WASCOP, which is the Wyoming Association of Sheriffs and Chiefs of Police. I do want to start by saying that the draft bill that we looked at online leading up to this meeting, we had some robust discussions across the state with our membership. A lot of concerns were raised on liability and so forth. And the changes that have been made to this draft bill that we looked at this morning alleviates most of that at first glance. But we haven't had a time as a membership to go through this carefully and look. But the one thing that the original draft didn't allow, and this one doesn't seem to address it either, is I feel like we should allow for an investigation and a finding of probable cause. So it has a lot of shall do this and will do this, and but what happens if we get to a point where that it's just not kind of going down that path of that person being there illegally. I think the wording that we put in there with the amendments that we've read this morning address most of that. We just need a little time to kind of go through that, I think. If we go through like page 4, line 19, there's that existing language in there that was from the previous version also, where law enforcement is charged with ensuring that there's no pending litigation related to the residential dwelling between the owner and any known unauthorized person. It's a very challenging burden for law enforcement to determine if there is or isn't. People could make a simple statement that I'm suing them, and we might act upon that and stop this when nothing's been filed in court. Access to those records in the courts and in the court where it's being filed, sometimes people will successfully file them elsewhere. But that's one of the things when we're working with civil documents in law enforcement is very hesitant because it bites us in the behind quite often. We're presented with evidence that we believe to be true and correct, and it's not the most recent document in that case. And next thing we know, we're getting sued for acting on it. Maybe putting some sort of reasonable expectation on how we find out if there's any litigation. Maybe even there is no known pending litigation related to the residential dwelling. Maybe it's just that simple. On page 5, starting on line 2, the committee just had some good discussion on that open to members of the public through permission of the owner. One thing that one of our members brought up specifically is, what if a realtor has an open house or a showing? And arguably the owner is allowing those showings or open houses to occur in the sale. And arguably houses on the market are most susceptible for these types of issues to begin with. So I'm not sure, I was trying to understand what loophole this closes to begin with. And I just think we might want to have some more discussion on that and a way to maybe tighten it. And then, Mr. Chairman, line 7 starts what would have been the biggest concern for our membership. I would say that our membership was would be very appreciative of this tenancy issue being put in here, because that was our concern from a liability standpoint. If someone had been a tenant and were afforded rights as a tenant and we got in the middle of that process, regardless of if the law allows it, I think it would bring liability onto law enforcement. And then line 12, we would agree that a better definition of immediate family would be appropriate. And then on page 6, line 21, there's that litigation issue mentioned again. And then on page 7, line 2, once again, that open to members of the public issue. And then when we look at line 15, we talk about, on page 7, line 15, the owner acknowledges that an unauthorized person removed from the property or dwelling under this section may bring a cause of action against the owner for any false statements. In our experience in law enforcement, that action doesn't get brought against the individual, it gets brought against law enforcement that did or did not enforce something. And I think it would be appropriate that if law enforcement is working off the information provided by a third party and are doing it with our best foot forward, doing a good job of investigating this, maybe there would be a portion in there or elsewhere in the bill that would limit the liability for law enforcement if acting in good faith on the information provided to them. And then on page 8, it starts to talk about the steps of the sheriff. There's been some discussion amongst our membership on whether this falls solely on the sheriffs in Wyoming or if it should be a law enforcement issue. I think there's some staff comments in there. But then this bill later in the bill goes into the civil process service fees for posting notices and things like that. I'm not aware of a mechanism for municipal law enforcement to do that. The statutes clearly say the sheriff does that. So if you were going to loop law enforcement as a whole into this, then there's going to be some crossover there with civil process service that maybe that might be best rested with the sheriff, even if the process itself could be done by any law enforcement. So you might, I don't know, that might complicate things, but you'd be looking at probably changing civil process service statutes in order for municipal law enforcement or state law enforcement to enforce this.
Couldn't the chiefs, Mr. Thompson, just Venmo the money over to the sheriff?
Mr. Chairman, I think that's definitely possible. I don't know how that Venmo stuff works, though. No.
Please proceed.
So on page 8, line 14, it talks about the sheriff shall verify that the person is a record owner. I think that there might be some concern from our members on how that process works. That process could take weeks, and that kind of defeats the purpose of, trying to make sure that this is addressed in a timely manner in 3 days and 72 hours and things like that. So that's, I think, just something that we might have to discuss a little bit more and see if we can't make that a little bit more manageable, I guess. And then page 9 talks about that service that that I just discussed on. And Mr. Chairman, I think that's all the notes that I scribbled down while we were going through the bill. But as I mentioned before, I think this is something that our membership is really going to be interested in discussing a little bit further, because most of our concerns that we had a week ago seem to be alleviated.
Mr. Thompson, thank you. Appreciate you being here this morning. Committee questions for the sheriffs and chiefs. Let's go with Representative Provenza and then Representative Oakley.
Thank you, Mr. Chairman, and thank you, Mr. Thompson. Can you remind us, because my recollection from the last meeting was that there were several counties, several law enforcement agencies that said that they can do something about squatters under the current trespass law. Can you remind us if your membership has made decisions about that?
Yeah, Mr. Chairman, so that was a discussion when we were looking at this bill in general. I don't have any specific examples of who said what, but there is a general consensus that if someone is illegally in someone else's property, that trespassing applies. And existing trespassing laws require that they be either told or notified through signs or, reasonable messages. But that could be simple as the owner telling them to leave and they don't leave, the law enforcement showing up, telling them to leave and they don't leave, and then you have a misdemeanor that occurred in the presence of a law enforcement officer, and that's arrestable offense. That does beg the question, is all of this needed to accomplish that same thing? And I just would like to go back to say that our membership hasn't looked at this. This might be a tool that is beneficial to them. And I don't want to speak on that until our membership's had a little bit of time to weigh in.
Follow up, Representative? Representative Oakley, go ahead.
Thank you, Mr. Chairman. So I kind of want to, I guess, get into this a little bit, discuss. You started out talking about, having the ability to investigate, clearly something law enforcement does and wants to do. And then we kind of ended quickly there on the verify, page 8, line 14. Starting at line 14, that subsection C. I think that this shall verify there is kind of key to this whole bill. So my understanding on that is that's where we'd get into that verification is what sort of kicks off and starts this investigation process. And I was thinking about saying that could take weeks. I in our group, I thought about bringing this up, but I think, and whether we want to actually create this language in statute or just, I think they can verify that at the local county assessor's office. So I know this is a little different for law enforcement, but I don't see that this is not in their wheelhouse, just because it is something a little different, right? So I guess, so with that, just wanted to hear your thoughts on that, verify and investigation process there on, in that subsection C. And then I've got another one, but we'll just go with that first. Just your thoughts on that, if that it seems clear, if you think we need to do more, what do you think about that being the sort of investigation piece?
Mr. Chairman, thank you for the question. I would say that 99% of the time, it's very easily during court business hours or courthouse business hours, Monday through Friday, that information is attainable in minutes. But when the property is listed to a trust and the trust members are absent and somebody's providing a power of attorney, we've got a recent case in Wyoming filed against law enforcement for acting on what they believe to be a power of attorney, later to find out that power of attorney was not in full force and effect. So I just say that I don't know. This wording might suffice to everything that we need to do, but there are times where ownership is just not immediately recognizable and we're being told differing information. So I just wanted to mention that.
Go ahead, follow up, Representative.
Thank you, Mr. Chairman. And so I agree, and I think, I mean, if we need to basically, we kind of had a little discussion on that verbiage, but that until it is verified, so shall verify, but until it's verified, then like, let's say there is something that takes a week, then it's not verified, so we don't move forward with law enforcement. So, but I agree, we even had some discussion and maybe some varying ideas when we were just even amongst ourselves, so then that points out right there, maybe that is something we need to break out a little more. Because I think literally those couple words are possibly the meat of this, and if we need to work a little further to give law enforcement direction on what that means. But it's also supposed to be the protection, if you will, that if it's not verified, then don't go forward. Anyway.
Mr. Chairman, I appreciate that. And as I mentioned before, we have a lot of discussion we need to have on this statewide. So, yeah.
Further questions? So, Ms. Thompson, this is not a question, but maybe just a conversation. There's really a couple of things that drew my attention to this bill. And one is the comfort of law enforcement to be able to do what it seems like to an average layperson like me would be reasonable, and that is to get somebody out of a property where they're not supposed to be. So to me, that was one of the goals of this legislation, would be to, what can we do for our law enforcement that helps them to feel like they've got a little better foundation? And then the second piece that I think is key to this bill is that it not take what was testified in that second meeting to us. We had someone from right here in this community say that it took, 2 or 3 months. To me, that just does not seem reasonable. And so talk to me about those two goals. And does this legislation meet either or both of those?
Yeah, Mr. Chairman, I think it might. I also want to be clear that the 2 to 3 month process for removing somebody from the house is typically what it takes to remove a tenant from a house in Wyoming. And so I think we're talking about two different things here. When someone is illegally in the house to begin with, that should be acted on as fast as possible to return that possession of that property back over to the rightful owner. But when there's an agreement in place for a lease, a rental type of thing, then there's rights afforded to the renter and to the owner. And those are things that law enforcement are not typically familiar with outside of the eviction process, writ of restitution process that's delineated specifically for sheriffs and statute. So we have a playbook for that. Sure. So this might be, I think, we do have some of our membership that would say this is unneeded because I can act upon this illegal tenant. But maybe this gives us a playbook, and maybe some people would feel more comfortable with this process and some perceived protections for us as long as we check the boxes. Then that would reduce liability for the actions based on this. So Mr. Chairman, we're just going to have to talk about this a little bit more and hopefully by this session be able to provide any additional comments that might make it stronger.
Yeah, appreciate that, Mr. Thompson, thank you. Anything else for the sheriffs and chiefs? Okay, thank you, Mr. Thompson. Look forward to working with you today. There's a couple up later in the day and further on this one. Oh, go ahead. Representative, go ahead.
Thank you, Mr. Chairman. Thank you very much for coming out, Alan. And so one of the things, we had that conversation about, should it just be sheriffs or should it be sheriffs and law enforcement? And I see sheriffs laced throughout this entire conversation, and then this idea of, well, maybe we should just have municipality, law enforcement, and that type of stuff. Give me your heart on that. Obviously, sheriff is in the realm of responsibility and authority in every county, a kind of already established structure that we have throughout statute and obviously across our country. So can you talk about, just give me your heart on that.
Yeah. Mr. Chairman, it's a discussion that our members have already had, thinking that the previous version of this without the process service fees and things like that was not quite fair to sheriffs because it looked like an action that any law enforcement officer in the state could perform. Now that we have the civil process portion of that in this statute, it kind of muddies that. So I don't know that I can give you an answer from our membership today, but I do know that there's a little bit of a concern that you have like you Sheridan County or maybe even Fremont County, you have a sheriff's office with limited resources covering a large square mile area, and you have a large municipal police department where everybody lives. So 19,000 of the 30,000 people in Sheridan County live in Sheridan. So it would be nice to have the help of the other law enforcement. And most of our law enforcement partners get along really well. So even allowing for that, I don't know how you would word it in the statute, but just an allowance for municipal law enforcement to assist county law enforcement in this process might suffice. But I haven't talked to our members about that, so I don't have a solid answer for you.
Follow up?
Representative, go ahead.
Thank you, Mr. Chairman. So kind of, if I'm hearing you correctly, you're basically saying like the sheriffs could almost dispatch municipality out in these situations where there's a large enough load where it would probably still run through the sheriff's department, but they could use the manpower of municipality law enforcement. Is that, am I hearing you correct? And I understand you're not, this hasn't been fully discussed and fully vetted, but that's just the conversation you were just entering into. Is that what you're meaning by that?
Mr. Chairman, maybe, but the problem with that is when you have two agencies investigating one thing, that's problematic to begin with. So, I guess I don't know the answer right now. I just think that it would open a Pandora's box if municipal law enforcement were collecting process fees for serving as sheriffs do all the time. It's.
Representative Harrelson, you good? Okay. Thank you. Okay, thank you, Mr. Thompson.
Thank you, Mr. Chairman.
We reserve the right to maybe ask you later.
I'll be here all day.
Okay. Anyone else want to testify on working draft point 7 of 002? Please come forward. Sure. Sheriff, good morning. We've been talking about you.
I'm used to it, Mr. Chairman.
Can you make that green for us?
I'm not used to this stuff too much, so.
That's all right.
All right.
You're in good hands.
Usually I don't need one of these anyways, from what everybody tells me.
Appreciate you being here.
Thank you. I appreciate being here as well. I guess maybe if it's okay if I.
Can you tell everyone who you are?
Yeah.
We know who you are.
I'm Clint Becker. I'm the Converse County Sheriff out of Douglas area.
Okay, the floor is yours.
Okay. So going back to what was just being discussed about the other agencies being able to step in and do things in the eviction process of tenants. There's two separate situations going on here. There's eviction, there's tenants for rentals, et cetera, and then there's also the people that are trespassing, basically being at a location that they really don't have permission to be at. And so state statutorily, the sheriff is responsible for all civil paperwork. And that's the civil process where, you have people that need to go to court, and we have to distribute that paperwork throughout the whole county to whoever comes through the court process. The rental situations with tenants is what we currently have in place in the statute is if somebody complains that they want to get somebody out of the rental because they haven't paid their rent, et cetera, there's a process in place, and that's a 3-day eviction notice. The 3-day eviction notice does not have to be served by the sheriff. We give them the option. The person that is the renter can put a 3-day eviction notice on the door of his place or give it to the renter, the rentee,
personally, and that starts that process. If they don't want to face the renter because they're in fear of the renter or something of that nature, then they can give us a $50 fee, and my civil process deputy will serve that paper for them. Once that happens, then and 99.9% of the time, the people do not leave the rental. So then the weight or the burden goes on the renter to get on a docket so that he can get a hearing in front of a judge where the renter would go and the rentee would go, and they would testify in front of the judge why this person wants to be the person to get kicked out of the rental, or the renter could say why he deserves not to be kicked out of the rental. So the way that I was explained to this years and years ago is that sometimes if a renter years ago had a family member that was moving back to town, he could kick out a renter just because he wanted his brother to have it, when the renter was being a good tenant and paying his rent and everything. So the process going in front of the judge basically protects the renter and the rentee from each other. So then if the judge makes a ruling on for the person who owns the rental property in the eviction of the other person because of whatever reason, maybe he's not paid his rent for 6 months, maybe he's not taking care of the property properly, then the judge will make a judgment. And all of this up until this time is civil. It's not legal. We don't get involved in that as peace officers until the judge makes a ruling. And then the judge makes a ruling, and then per what the judge rules, then that gives us the authority to eventually forcefully move that person out of there, et cetera. So that's kind of the whole process. I don't see an issue personally with this rental situation. If it's still a civil process as far as us not having to serve the 3-day eviction notice unless the renter requests us. So it's kind of a 50-50. A lot of people just do it, tape it on their door, and that starts the whole civil process through the courts. Now, in Converse County, we're not like in Casper. I don't know, we can handle that request by the renter to post those notices. Well, it's a lot different in Casper as far as, the size of the city and everything. So I don't know what the process would be for the board to change the civil status of the sheriff, which is one of our state statutory duties as the sheriff. I don't know that process. It would be tough, but as far as the need for us to serve, the only reason that people have us serve is because of their fear, possibly, that they don't want to be involved. They'd rather pay the $50 and let us handle the notification. Then it's easier, maybe a little bit easier that it's on record. So that's, I just wanted to give you kind of the gist of, would I have a problem with the local entity stepping in and assisting with the notification? No, not really, in that type of process. So I don't know if you have any other questions for me.
Sheriff, I appreciate it. And you're absolutely right. This, this runs parallel kind of to our landlord-tenant laws. And
Right.
we've got good real estate folks here that know a lot better than me. But I think the goal was to not do anything to damage or interfere with that landlord-tenant work that's been done through the years. Appreciate you kind of highlighting how that takes place. But go ahead, Representative Chesty.
Thank you, Mr. Chairman. Sheriff Becker, you discussed the civil, the two cases. There's the rental case, and there's the actual squatter case where they have no claim of right whatsoever.
Right.
You talked about the first case, but what about the second case? Are you seeing any problems with the existing statute for trespassing, and why is that statute not sufficient to deal with that second problem?
For us, it's been sufficient. But then again, I can't talk for the larger cities. You know, we have Douglas, which is 6,000 people, and we have Glen Rock, which is around 3. And then we have 4,200 square miles. That is our county that, roughly, including me and my undersheriff, probably around 20 deputies cover that larger area. We have a civil process, one civil process person in Converse County. Well, we have a process group, but one person that will generally serve papers throughout the whole county, and the deputies will jump in and serve papers, and not just on all court cases and any civil type paperwork. So, but I can't really relate to Casper and the sheriff here, because he's got to have a much larger, because of deputies. As far as the trespass laws work very well for us, but then I don't have the same problems that they have so I can't really speak for the larger areas of the sheriff, the larger areas. I can just speak for us. And the trespass, we just go, it's fairly simple for us. But I think the biggest issue that I get concerned with is putting my deputies in a position in a civil nature where we don't have authority to be there. But if we have a complaint from an individual that says somebody's moving into my barn or somebody's campers on our property, then we can go discuss it. We can go approach that person with that camper and say, hey, we have authority, belief that you're not supposed to be here. Do you have permission to be here? And if they don't leave, that type of thing, we can, through our investigations and things, we can determine that, okay, and we can actually go into a legal realm there for trespass, because we have laws on that, which work for us. So.
Thank you, Sheriff. Further questions? Further questions of the sheriff? Thanks for being here. Appreciate it.
Thank you for your time.
Anything further, excuse me, anything further on working draft point 7? Would anyone else like to come forward? Good morning. It's good to see you. If you would please introduce yourself for the formality of the process.
Good morning, Mr. Chairman. My name is Mike Thompson, Chief of Police for Evansville, Wyoming. A couple things I want to bring up. I think the intent of this is good. We need it in the state, but this particular draft has a lot of mud for us in law enforcement. As Sheriff Becker testified, the civil process is part of that. Municipal officers, we don't do any processing, serving of papers, and so that's part of the mud of this. But one thing I want to bring up, when you look at this, it talks about residential dwelling, and I don't think squatting isn't just two residential dwellings. It can be any particular property, and so that's part of the mud of this. You take like a camp or a tent or like an RV bus; those can be considered, residential dwellings in a sense by law. So when they show up to open property, and Natrona County is unique place in the state because we have so many municipalities that touch each other within our county. And a lot of the times we have people that, they get kicked out of one municipality and have an issue, and then they end up another one. And just a couple of weeks ago, we had 4 incidents in Evansville with homeless type people One showed up on if you're familiar with the area, so we had the John Deere dealership, and they showed up on open property, and they were living in a tent out there. And so in the mud of, is that a dwelling? And then it goes back, do they need to be served because they could be considered a tenant? Because in some way, we don't know how long they've been there, and as we deal with this stuff, and people come all the time, well, my roommate let me live there, or they get their mail, and there's so many confusions of that. So I think that's something that needs to be dealt with. And something that was talked about earlier, the duty to find out who owns the property, and I can testify how complicated that can be. As an example, I have a storage facility that I own here in Natrona County, which is filed under a LLC, which is owned by another LLC in Montana, which is owned by a trust filed in Las Vegas, Nevada, and it was pre-digital age. So to ever truly find out the root of that trust, you'll never find it. So for a law enforcement officer, that's a lot of time, and they may never actually find the answers to that. My mother has a trucking company that she owns, and she has an LLC in the state, and then that is owned by a Delaware corporation. That's a lot of time. And when you talk about protecting property is dealing with squatters, the damage and the time that goes on with that can be substantial. So a couple of thoughts. Looking at other states, they have, and it may be a simpler way to address this, they've simply just classified squatters as being a criminal act. So like West Virginia and even New York for the far eastern states and how they address this stuff. And it may be a simpler way to protect property across the state, not just as residential dwellings, but all property. And it may be a better way to look at it and redefine things. Stand for question, Chairman.
Chief, thank you. Appreciate it. Excuse me, let's go to Representative Oakley.
Thank you, Mr. Chairman. Okay, so, and this is good discussion, but I do feel like we're, starting to move around a little. So we've talked about how trespass, somewhat, we've talked about maybe trespass is fine. But then, then we're talking about the difficulties. So I kind of like the idea of putting parameters around, but then you said, we're talking about, and this is really the question, that maybe this residential, this definition of residential property is too narrow. But it seems to me that then you mentioned RVs, tents, storage units. I think that's what would make it messy. I think the idea in my mind that at least this is my thought on this bill, is that we're trying to keep this specific and narrow, not about renters, not about tenants, not about eviction. This is a specific, narrow about people squatting in a house. And so if we keep it as narrow, and so because of different things you brought up, so if we keep it as narrow as residential dwelling, does that alleviate some of your concern? Because then our residential dwellings are connected, like with our assessor, right? Where storage units might not be, certainly RVs and tents. But those seem more open to me to the trespass. So you handle that this way, and we keep this as narrow and specific as these squatters in homes. I mean, so if we keep focused on this, what does that do for your thinking? Does that alleviate some of your concerns?
Chief Thompson, go ahead.
Mr. Chairman, Representative Oakley, it's a good question. Each jurisdiction in the state has its own problems that come with this. And in some places, it probably would work that way, but in other places where we have more transient people that move around, I think it will become more problematic for those who have these people end up on their properties versus just the dwelling. And then they're going to be upset when they come to, whether it be the sheriff's office or the municipal police forces, and say, well, why can't you help us? And if it's narrowed to just residential dwellings, then we're going to have to articulate to them why we can't help them, and that becomes more frustration. And I think in the long term, then they're going to be coming back to the legislature and or the elected representative saying, hey, this isn't fair to us as landowners beyond residential dwellings, if that answers the question.
Go ahead, follow up, Representative Oakley.
Thank you, Mr. Chairman. And Chief, but that to me begs the question then, so is trespass sufficient? Because then what I'm hearing is then, well, you know, that I'm hearing trespass already works. Well, then why can't that trespass be used for those and separate this out? It seems to me that you're saying, well, if we can't do it perfectly, then we might as well not do anything. When we're separating these types of properties out, but which to me makes sense to do. And so anyway, like I say, the answer kind of begs the question, so is trespass sufficient or is it not?
So does Chief Thompson, go ahead. Yeah.
Mr. Chairman, Representative Oakley. I think in generally, trespassing can work for most of this stuff. You know, there was some discussion earlier about, you know, that it needs to be posted and different things like that and duly notified, you know, whether it be by the owner. But that goes back to also like, you know, we talked about earlier with, you know, owners of property that aren't necessarily around all the time either. And sometimes, you know, looking at that, you know, did they notify them? That goes back to that ownership, you know, that time of ownership too. And sometimes, you know, if you're an owner in, say, Denver, Colorado, and you own an apartment in, you know, Evansville, Wyoming, or wherever it may be, I think that could be, I think trespassing generally would work, but I think the intent of what you're trying to do is to clear up some of that. And again, you know, if we cite somebody or arrest them before the trespassing, and we have a judge sitting back here because, and some of the judges have different viewpoints of law and what is an appropriate notification. Representative Oakley, not totally clear, but yes, I think trespassing generally could.
Further questions? Representative Crago.
Thank you, Mr. Chairman and Chief. So just two questions. One, you talked about it's difficult to determine ownership, and I agree there are times when that's the case, but wouldn't it work at that point? So you make an initial call to the assessor's office and say, who owns this property? Assessor says it's owned by a LLC. You can't track that down. Can't you put that back on the owner and say, I'm going to need proof of ownership. You want me to do something about this? You're going to have to show me that you own it. Would that work?
Go ahead, Chief.
Mr. Chairman, Representative Crago, absolutely. I think that would be one way to clear that up and put the burden back on them to show ownership.
And just a
Go ahead.
quick follow-up, Mr. Chairman, and you know, I think that's part of our idea. The working group had that additional language in there. If you're unable to verify the ownership and that they're entitled to relief under the section, then nothing happens, right? I mean, I think it was clear. It was in the proposed bill draft before, but I think we made that clear or tried to make that more clear with the proposed amendment. And then just another follow-up question. You know, we're talking about all these other. You know, we're talking about trespass or, you know, creating a squatter's law or whatever, all of those things, whether it's this, you know, whether we use this tool or some other tool to address the problem, it's going to require investigation by law enforcement or, you know, whether it's the police department or the sheriff's department, someone's going to have to investigate. You're not just going to roll in on a report and throw somebody out without looking into it. And is that fair?
Mr. Chairman, Representative Craig, that is correct. An investigation, I think in the intent of what we're doing, if we can clear up and streamline things, that helps us. Because again, like as a side example, you know, an owner can come in with the documentation to say, yep, I own this. And I think the intent is that we at least verify that. But again, like, you know, when we have two people with a domestic or a child custody case, unless the court specifically gives us that paperwork, we just don't take, you know, if somebody says, yep, here's my court order, because then somebody else can say, well, this is my court order. So I think if the burden's put back on them, but we've got to have probably a clearer way to establish that they are actually the owner too, because nobody's ever falsified documents. Representative.
Yeah. Chief, thank you. We reserve the right, if you're still here, we may ask you a question a little bit later. Really appreciate you coming. Thank you.
Thank you.
Okay, anything further on this working draft? Good morning, Ms. Urbichai, good to see you. Please introduce yourself for the good of the cause and for those streaming in and all across the state.
Thank you, Mr. Chairman. Lori Urbichai with the Wyoming Realtors. Thank you for taking this bill up again. We do think it's important, and I only have like 2 comments on it. On the page 5, when it talks about the residential, excuse me, dwelling was not open to the members of the public, the more I read that, the more it concerns me. Because indeed, we could have an open house, a realtor with permission of the owner has an open house, it's a vacant home, people wander through. This says, at the time the unauthorized person entered the residential property. What if they entered and left and then came back and broke in? I don't like that language, really. I think that causes some problems. That language, I believe, came originally from the Florida statutes. And why they had that in there, I do not know. But that one concerns me. Plus, they could have come to the open house, hid in the basement, closet, whatever, and then just stayed. So I think, I don't see that that language is really necessary. And then my only other comment is on the next page, the date of which the residential dwelling was purchased by the owner. And as I testified last time, sometimes properties aren't purchased, sometimes they're inherited. And I don't understand why the date that that happened is important. If they can prove that they own the property, and I certainly agree that it should be the owner's duty to prove that they own the property, I don't see that that date is necessary. I went back and looked at my property in Fremont County, and I did actually find the date by going with their GPS system on the county, the actual date that I purchased the property, but I'm not sure that a lot of people would dig that deep to find it. I guess you could call the assessor's office and find out when that deed transferred, but I definitely don't think we should have the word purchased in there.
Okay. Ms. Urbichai, thank you very much. Representative Provenza.
Thank you, Mr. Chairman. To your last point on the date on which residential dwelling was purchased, I guess one of my concerns, or what I think about with this would be someone purchased the house recently, the people that lived there before were renting, they should be given formal process, right, through the other section title. Are you familiar exactly with maybe how that would work when someone purchases a home, there's renters, and what the maybe risk is for the person living there?
Mr. Chairman, and I actually just thought that same thing as I was talking about this. So possibly if we change the wording from dwelling was purchased by the owner, was acquired by the owner. And then I guess they'll just have to do that search, because I did just think of that. What if there was a transfer and there were tenants in there?
You good? Anything else, committee? Mr. Co-Chairman, go ahead.
Hey, Mr. Chairman. So I'm wondering about the possibility if the owner of the property signed an affidavit swearing that I'm the owner of this property, this person is not a renter or a tenant, a lot of these other qualifications that are set forth in this bill. If we had the owner sign under penalty of perjury an affidavit, do you see that as a mechanism perhaps of taking the liability off of the law enforcement officer and putting it squarely on the person who signed that affidavit? Do you see any potential merit in an approach like that?
Mr. Chairman, exactly. And that's why I think this is an important bill. And I agree that we need to keep it narrow and keep it focused. But I think that is the issue in a lot of areas, is the concern of the liability of the law enforcement officers acting. So yeah, I think it's very important.
That's a good point. Okay, committee, anything for the realtors this morning?
Thank you,
Really
Mr.
appreciate
Chairman.
it. All right, thank you very much. Okay, is there anything further from anyone in the room today on 002? I think that we have somebody online this morning, and I've split these two bills up. Oh, excuse me, please come forward. I didn't. Absolutely, no, come on up. We want to get to the room first, and then we'll go to anyone streaming in. I think we do maybe have a comment online, and we'll get to a couple of folks after you. So please introduce yourself.
Yes, I am Candace Machado. I'm the mayor of the town of Evansville. My chief spoke earlier. I'm just kind of going to add on to what he was talking about. I think it's important to note when we're talking about the dwelling piece that yes, we could look at specifically the residential section of the property, but we do also have to look at, clarifying the jargon and the wording of what a dwelling is, because, for instance, I have a cabin on Casper Mountain, and a lot of cabins have been broken into lately on Casper Mountain and within the last several months. And when the cabin owners only use their cabin for a set number of time, and there's someone that's staying in the cabin that's not supposed to be there, the owners are being met with confusion, concern on why law enforcement can't do anything, because there's some concern about whether or not if a cabin is a residence or not, because it's a seasonal. It's the same thing in Evansville, where we've got people who are living out of sheds or living in tents down by the river or what have you. So I would just ask that we consider and think about, when we're talking about a residence or a dwelling, what does that actually look like? Because my chief and I have had lots of conversations about, well, what does that mean? And how do we move forward? And how do we address these certain things when it comes to a residential section or a dwelling? How do we move forward with that? And specifically from my standpoint, being the mayor of Evansville, it's hard to move forward when our hands are tied from that standpoint. How do we move forward? So I think it's important to have that clarification. I absolutely agree with my chief that it does tie their hands from a law enforcement perspective when we're not really sure how to address a residence versus a shed or a tent or a storage unit that's not attached to the home. Is a garage that's not attached to the home, is that a part of a residence? So there's some confusion there. So I would just like to throw that out to everybody, that would definitely be a concern on my end as the mayor of a town, on how we move forward in addressing those kind of loophole areas that may not be as clear. And I think it's important to create clarity when we're looking at things such as this. Just my 2 cents, though.
We appreciate that, Mayor. Thank you. Appreciate you being here. And anything, committee for the mayor of Evansville? The beautiful, wonderful committee, community that I used to get to represent. I don't represent Evansville anymore, and that breaks my heart, but thank you for being here.
Thank you.
Really appreciate it. Anything further from anybody else in the room? 002, we're taking up the squatters bill. Okay, let's go to online testimony. I understand we have a couple of folks waiting.
Yep, Mr. Chairman, we have Jim Manley online and Karen Schreiber.
Let's take, why don't you select, Clarissa, whichever one you want to, who do we have this morning? Good morning. I'll have one of you just introduce yourself and welcome. Let's go with the first one, Clarissa. Who is?
Mr. Chairman, we'll go ahead with Jim first, if that works okay for you.
Okay.
Good morning, Mr. Chairman, members of the committee. Thank you for the opportunity to appear online. I'm sorry I can't be there in person today. I did submit written testimony, but I just wanted to highlight a few points from that. My name is Jim Manley. I lead state legal policy for Pacific Legal Foundation. PLF is a national nonprofit law firm was founded 50 years ago by members of then Governor Reagan's staff in Sacramento, hence our Pacific name. But we litigate and work on policy nationwide in the areas of property rights, separation of powers, and equality and opportunity. And so from a property rights perspective, this squatters issue has been top of mind for us. Along with my written testimony, I submitted a report that my colleagues drafted on the state of this issue nationwide. And as you'll see in that report, more than a dozen states have considered legislation on this issue. At least 9 states have passed bills quite similar to the one that you're considering today. And we at PLF see bills like this as very important to really, as Chair Landon suggested, protect and empower law enforcement to act in an area where they really ought to be acting, and where many law enforcement officers are feel that they're able to act, but some feel stymied by the laws that currently stands. And a law like this empowers and protects them to act in a situation where property rights are at risk. And I think I just want to focus the committee's attention to the parts of the bill. Some of the discussion this morning has addressed areas where there's confusion about whether there's litigation going on, about who owns the property. And this was highlighted in some of the discussion, but the onus is really on the owner in this situation to provide law enforcement with the information that they need. And one change I might suggest in the bill is to emphasize what the bill already does, which was place the burden on the property owner and the onus on the property owner for mistakes. The bill already on page 7, line 15, makes it makes it clear that law enforcement is not liable for damages that occur. I'm sorry, that's page 11, line 17. On page 7, line 15, if a person is removed from the property based on false statements that are made by the owner, that person has a cause of action against the owner. And model legislation that PLF drafted on this issue also makes clear that law enforcement wouldn't be liable, and in fact, the owner would be liable for any damages that someone might suffer because of a false statement made in the affidavit that the law enforcement officer is relying on. And so, again, just by shifting the onus to the owner of the property for any false statements that might be made that law enforcement might rely on, I think that addresses a lot of the concern that law enforcement officers have raised this morning about potential liability. And I'd be happy to provide the committee with a link to that model legislation and that language that might help bolster the liability language that's already in this bill. I agree with Chief Thompson. The bill could be broader. We've heard from folks across the country who've dealt with this issue on agricultural property, on commercial property. But from my perspective, what we've seen nationally is a lot of legislatures are focusing on this issue first in the residential context. And that creates a framework that can be expanded as the need arises and as folks get more comfortable with the framework that's put in place for residential properties. So my hope is that the committee will advance a bill, even if it is narrowly focused on residential property, to address this important nationwide issue that is imperiling property rights across the country. And as we heard at the last interim committee meeting right here in Wyoming as well. So thank you. I'm happy to answer any questions.
Mr. Manley, thank you very much. And I apologize for the confusion up front. We had a couple of you ready to testify, and we'll get to Mr. Schreiber here in a minute, but appreciate you being here this morning. Mr. Co-Chairman, you've got a question for Mr. Manley.
I do. Thank you, Mr. Chairman. Mr. Manley, my question is, as more and more states are passing these kinds of bills, what kind of litigation are you seeing around the country? Are these bills holding up to legal scrutiny?
Mr. Manley, go ahead.
Mr. Chairman, Mr. Co-Chair, I'm not aware of any legal challenges to these sorts of bills. What they've done, so I can tell you anecdotally, in New York, we were monitoring a situation and we're going to potentially get involved in litigation that was mooted because of a law like this being passed. The woman that we were talking to there was covered extensively in the news. Her parents passed away and she was maintaining their home, but she only went to the home every 6 months or so. And one time she drove by and people had moved in and they claimed without any basis to have the right to be there as tenants. They were just trespassers. And this woman was actually arrested for changing the locks on her own home. If not for legislation similar to this passed by the state of New York, we probably would be in litigation already. So I suppose one answer to your question is that bills like this can reduce the potential for litigation. And I'm not aware of any legal challenges to bills like this.
Okay, thank you, Mr. Manley. Anything further for Mr. Manley? Again, we really appreciate it, Mr. Manley. Thank you for checking in this morning. It's been very helpful, and we will move on to Mr. Schreiber. Good morning.
Good morning, thank you. Good morning, members of the committee. My name is Mason Teague. I am currently a second-year law student at the University of Wyoming College of Law and the 2L legal assistant in the Civil Legal Services Clinic. I am here today with the Civil Legal Services Clinic faculty director, Professor Karen Schreiber, to share our opinion about the Unlawful Occupants Bill. Nothing I say today should be construed as a statement on behalf of the University of Wyoming Civil Legal Services Clinic or the College of Law. I will be sharing only my own opinion and that of Professor Schreiber's, and we urge you to vote against the Unlawful Occupants Bill. I would like to begin by talking about the language the bill uses to define people subject to the process contemplated in this bill. The bill uses the term unauthorized person, and assuming the current proposed language is incorporated into the bill defines the term as a person who is not authorized or is no longer authorized to maintain presence or residency in a residential dwelling. This language is overbroad and can be applied in ways outside of the scope intended by the bill. For example, if a tenant has a lease with their landlord to live on a property for 1 year, and the tenant holds over following the expiration of the lease, under the language of this bill, the tenant is a person who is no longer authorized to maintain presence in a residential dwelling. Therefore, rather than going through the existing legal process to evict this tenant, the landlord or property owner of the dwelling could get the sheriff's office to immediately remove them from the property. In my opinion, the best way to make sure the bill's language is not overbroad is to use the legal term and definition of squatter. According to Black's Law Dictionary, a squatter is someone who settles on property without any legal claim or title. In Wyoming, we do not have squatters' rights, which is why this term is not defined anywhere in our statutes. If the concern is that someone may take over an owner's property by squatting, Wyoming landowners should know that in Wyoming, squatters don't have the ability to gain title or a continued right to occupy any property simply by being present on anyone's property. If the concern is that a person has broken into a property and is illegally using it, the property owner can criminally trespass that person under Wyoming statute section 63303, which provides for the removal of a person who unlawfully entered or remains on another property without permission. The language in this Wyoming statute tracks the legal definition of a squatter and provides for the quick removal of a person who is unlawfully on the property of another. And it also does not interfere with the rights of tenants, licensees, or other authorized occupants. Additionally, this bill may allow property owners and landlords to avoid the current existing judicial process to remove an undesired tenant or licensee. A tenant is a person who has entered into a written or oral lease with a property owner to temporarily occupy land or property. If a property owner wishes to remove a tenant, they sue the tenant for eviction. On average, it takes less than a month for a landlord or property owner to evict someone in the state of Wyoming. The eviction process is simple and inexpensive. Property owners and landlords must give the current tenant a notice, which gives the tenant 3 days to cure a condition or move out before a tenancy is terminated. For example, a tenant behind on rent will have 3 days to cure or pay the overdue rent, and if not, the tenancy will be terminated, which allows the landlord to sue the tenant for eviction. To start a case, a landlord files an action in the circuit court. Here in Casper, a court date is usually set as fast as 10 to 12 days from the time the landlord or property owner files the complaint. The tenant is not required to file an answer and has to be notified about the case only 3 days before the date of trial, which is the first court date in the case and likely the only court date. Since this process is so quick already, there is no need to create more laws to circumvent or avoid the existing.
I think we're froze up a little bit. So if you can hear us and We will hang on for just a moment and just know that you're frozen up at this point. And committee, my apologies to you. I didn't have this young gentleman's name in front of me. And I only had what apparently is a fellow professor of the representative to my left down here. So I did not get his name properly. So I want to do that if we can get him back on. Looks like we've lost him for this morning for now.
But he tries again.
Representative Chesty, go ahead.
This is Mason Teague, Teague.
And it's Nathan, is his?
Mason.
Mason.
Mason Teague was his name,
Okay,
actually in my class this semester.
okay. Appreciate you clarifying that, Representative, and it's good to have him weigh in. I'm sorry that we lost him midstream there. For now, let's. Okay, Mr. Teague, you're back on with us. Can you hear us? I think you are muted at this point, so if you can unmute.
Mr. Chairman, he's unmuted on our side, so I think they just need to adjust the settings
Okay.
on their end.
Can you
Mr.
guys
Teague?
see me and hear me?
We can hear you now, and you were doing great. We lost you midstream there. So want to give you an opportunity to finish up whatever comments you have on the bill.
Perfect. Thank you so much. I apologize about that. So I'm not sure where I was cut off at, but I will start with where I think I lost you.
Okay?
So this bill places law enforcement in the role of the fact finder, serving as both judge and jury. The bill's proposed language suggests that law enforcement review and weigh evidence from only one side, determine who is lawfully entitled to possession or occupancy, and remove the individual who is deemed to be unlawfully on the premises. The eviction process was created to ensure due process for both property owners and occupants and requires a judge to issue a court order before someone is removed from a home. Law enforcement is already overworked, and adding this additional responsibility to their jobs is not necessary where there is already a legal eviction process in place. This bill could lead to the removal of someone who is in lawful occupancy because the landlord or owner made a mistake by assuming the person is an unauthorized occupant, subject to the process contemplated in this bill. The eviction process exists so the fact finder, judge, or jury can hear the evidence presented and make a quick but informed decision about who is lawfully entitled to occupancy of a property. In closing, we ask that this committee vote against this bill because it is duplicative of both the existing criminal trespass statute and the current eviction process. Property owners or landlords may use these existing mechanisms to remove unwanted people from property expeditiously and economically. Professor Schreiber and I greatly appreciate the opportunity to be heard today. Thank you for your time, and I'm happy to answer any questions.
Thank you, Mr. Teague. We appreciate it. Committee, any questions? Any questions? Really appreciate you weighing in this morning. Thank you very much.
Thank you.
Is there anyone else, Larissa, that we have waiting online? Okay, I'm going to close public testimony on this bill. Committee, what's your pleasure on the bill?
Move the bill.
Okay, moved by Representative Oakley and seconded by Co-Chairman Washut. Discussion. Committee, I will throw out there that I like the bill. I think it may not be perfect, and we've got some opportunities to talk about a couple of staff comments that I think might strengthen the bill. After I've studied the bill, I think it adds to the capability of law enforcement, but it also is protective of some property rights. You know, the testimony that just finished, for example, talks about, well, it's pretty quick, you know, in a month's time, you can have somebody back out of your house. Well, I've got constituents, if they come back from Phoenix, for example, have been down there during the winter and come back, and you tell me that a month seems reasonable? That doesn't seem very reasonable to me if somebody's living in their house. One of the reasons I think that we focused our attention on residential dwellings to start with here is that That's pretty important to people. It's one thing if they've got somebody in the garage, but it's another thing if they're in the house. And so I hope we can work the bill and see if we can make it a little better, but I kind of like the track that we're on. Anybody else? Representative Rodriguez-Williams.
Thank you, Mr. Chairman. Good morning. I just have a quick question for LSO, if I may.
Absolutely, go ahead.
So in the previous, the last testimony, there was a suggestion that we use the term squatters in lieu of unauthorized persons, or however it's phrased in this, in the bill. And I just curious about LSO's opinion on changing that and incorporating that into statute.
Brian, any thoughts? Go ahead.
Mr. Chairman, Representative Rodriguez-Williams, no, I think that's a policy decision for the committee, whether that term is used or not. I think how it's defined is probably more important. And the one thing I would note, maybe just for consideration, so page 2, line 20, the language "or is no longer authorized," in light of the addition of the paragraph, in particular, that the unauthorized person is not a current or former tenant, the committee may wish to consider deleting that part, so "or is no longer authorized," since that, if that paragraph concerning, a former tenant, that may help with clarity.
Thank you, Mr. Chairman. So for discussion, and then I'll make that, that suggested amendment. So it seems to me, I do, and I'm getting more convinced, actually, with the discussion. I do like it. It seems to me almost contradictory. We keep saying that trespass is fine, but then as we flesh this out, we see that we need to understand more and have the processes, and that's exactly what this is trying to do. And then the discussion also keeps coming back to eviction. And again, that's what this highlights. We are not talking about eviction with this. This is not tenant law. These are not tenants. And so dividing that line to me makes sense. And as we talked about it, so then this creates the tool, this creates the process by which they can take care of this specific issue. So I'm liking that. I think there needs to be some discussion on the municipal officers versus the sheriff. I really appreciate hearing from law enforcement, and I don't think we're trying to change the service of process, that's a sheriff's office function. We're trying to, at least this is my understanding, so if we can, if everybody agrees, we can get this down. This is about, because a lot of residential dwellings are under the purview and within a city that might have a capable police force. So allowing them to do this investigation as well. So that we want to keep it that they can do this process, but not starting to mix those lines of the things that are really traditionally under the purview of the sheriff's office. So if we can get that cleaned up within that, I'd like to do that. I personally would like for them to be able to do the investigation without, like I say, changing the service of process that's under the sheriff's office. So with that, I guess we can start doing, we can look at that, but my amendment is the one that Mr. Fuller just made, which would be to page 2, line 20, strike "or is no longer authorized."
Okay, seconded by Representative Crago. So committee, we will go ahead and launch into working the bill. I'd welcome any comments afterwards. I didn't mean to interrupt that, but we do need to work it. So anything on the amendment? Does everybody understand? All in favor of the amendment to line? Oh, excuse me, Representative Chesty.
Thank you, Mr. Chairman. I support the amendment. I think it's a good amendment. I was going to make that amendment myself. I actually do like the suggestion of Mr. Teague that we use, instead of this section, we use the words, we define what a squatter is. but I don't have that language available, so I'm going to support this amendment right now. And during session, I may come back with a replacement definition to use squatter instead of unauthorized person.
Good thoughts on that, Representative. I apologize. Everybody ready for the question? All in favor of the motion, please say aye.
Aye.
Any opposed, no. That motion is carried and adopted on the bottom of page 2. Anything on page 3 regarding sheriff or law enforcement? Representative, good morning.
Yeah, Mr. Chairman, I propose that just in the trespass portion of the bill, strike sheriff and put in peace officer or law enforcement. Whatever appropriate.
Representative, are you going right to line 17 on page 2? Is that?
Correct, on line 17. And I think there's a couple other spots in the bill. We can get to there.
We would need conforming amendments, Representative, but so you would strike the sheriff in the county and replace with law enforcement?
Correct, sir.
In the county? Okay. Everybody understand the motion? Do I have a second? No? Question? A second from Representative Oakley.
Mr. Chairman.
Okay, now we can have some discussion, all right? Brian, are you clear on what is being suggested? Go ahead.
Yes, Mr. Chairman, maybe 2 questions.
Sure.
So the first question would be, is the intent then that other law enforcement could assist except for the service of process, or is the intent that's?
Mr. Chairman, yes, correct.
Okay.
Representative,
And then.
what you meant, go ahead.
Yeah, and then, Mr. Chairman, the next question would be, peace officer, as defined in statute generally, is quite broad in terms of those officers. And so, Mr. Chairman, my question would be, is there some intent in terms of who exactly among law enforcement can or cannot assist with this process?
Well, I think that's a good caution, Brian, because you're talking about everybody, including game wardens, right? So I think we might want to drill down a little deeper, folks, and make sure that we're talking perhaps counties and municipalities, and how do we get there, Representative? Does that make sense? Mr. Co-Chairman.
I think if we put municipal law enforcement or the sheriff in the county.
The motion and the second, does that seem like a friendly amendment?
Very friendly, thank you, sir.
Okay, all right. So a request from, state that again, Mr. Co-Chairman, if you would, on line 17,
Line
page 3.
17, request from municipal law enforcement or the sheriff in the county.
The motion and the second are okay with that?
And Mr. Chairman, maybe the simpler way
Back to you.
Yeah, Mr. Chairman, I think a simpler way to do this would be to either use the term peace officer, or maybe more appropriate for this bill, law enforcement, and then define that to mean the sheriff or a municipal officer.
Yeah, I like that.
And then, Mr. Chairman, the places in the bill where it describes the service of process, those will remain the sheriff.
Brian, that really becomes an amendment draft that we would rely on you upon. Are we clear with what the committee is trying to accomplish here, Brian? Are you good? And committee, I'd like to go in the direction where Brian just outlined for us what might be the best. Just state it and then provide the definition. Would you do that in just the following sentence, for example?
So Mr. Chairman, on page 2, after line 11, I would add a new definition, either law enforcement or peace officer. I'm not sure it makes law enforcement may be better to avoid confusion with the use of peace officer. Law enforcement means sheriff or municipal officer, municipal police officer. Then, Mr. Chairman, in most places in the bill, so like page 3, it would be requests from law enforcement in the county where the property is located. And that would continue, page 5, line 18, sheriff, submit to law enforcement of the county. And I can keep going through, that's the general gist.
I think the committee understands conforming throughout. Is everybody understanding of where we're targeting, where the language we're targeting is? Okay, and what we're attempting to do? Everybody good on that? Representative Provenza.
Thank you, Mr. Chairman. Mr. Fuller, would we need to potentially amend 18-3608 to charge fees? Are we going to have any concerns with fees for law enforcement? Is that adequately addressed?
Brian?
So, Mr. Chairman, Representative Provenza, my understanding with the thrust of this amendment is the sheriff would still serve. And I think the way the bill is drafted, the sheriff would receive that fee that's in current statute. And then that next subsection would allow law enforcement to charge a reasonable hourly fee if they have to remain on site while, while personal property is removed or keeping the peace.
Thank you, Mr. Fuller. Representative Craigo.
Thank you, Mr. Chairman, and I wish I, to be honest, would have asked Mr. Thompson, our good chief and our sheriff, this question earlier, but it just occurred to me is, do we have to call this service? I mean, can it just be a notification? Does it have to be a service? Does it have to follow under the service of process statute? Why can't it just be a notification? And then anybody could do the notification. Local law enforcement, i.e. the police, could do the notification. It could be the sheriff. It doesn't have to be the sheriff, because then you're mixed. I foresee this where the local police department's doing the investigation. They determine that, yes, you qualify, the unauthorized person needs to be thrown out. And then they have to coordinate with the sheriff to actually serve a notice, whereas they could just show up at the door and say, yep, we got a complaint, we verified the complaint is accurate, you're out of here. I think we're trying to make it more complicated by the whole service of process thing, when it's really not a service of process. It's notifying them that they have to leave. So I don't know what their thoughts on that, and we could work on that later, but that's one of the things I'm sitting here thinking. Thank you, Mr. Chairman.
I'm getting a head nod or two that you might be headed in the right direction, Representative. Representative Rodriguez-Williams.
Thank you, Mr. Chairman. If I could just piggyback on that last comment and Representative Provenza's comment too. Some of the testimony that we received from WASCOP was that there was no mechanism in place for municipalities to charge. And so on page 11, line 13 through 14, Representative Provenza brought up that the sheriff may charge a reasonably hourly rate, I guess, with conforming amendments expanding past the sheriff to municipal law enforcement. I think we have to take that into consideration as well.
Thank you for that, Representative. So back to what is now a conceptual amendment with the help of Mr. Fuller. I want to go back to the representative who made the motion and make sure that you're comfortable with where this conversation has gone. And then we had a second to what you were up to. I want to make sure that you're both comfortable and feeling okay with where we're going here. We've moved all the way to a conceptual. Does everybody understand where we are on the bill? Okay. Is there any further discussion on the amendment? Anything further?
Yeah, Mr. Chairman, just one question.
Mr. Fuller, you bet.
Mr. Chairman, the discussion on the notice, is that being incorporated now, or are we waiting for that separately?
I think we treat that separately when we get to page 11, folks, so let's remember that.
Thank you, Mr. Chairman.
Let's not cloud any further than we already have. Mr. Fuller, thanks for helping to lead us out of out of the weeds here. Mr. Co-Chairman.
Thank you, Mr. Chair. I guess I'm uncomfortable with conceptual amendments at our third meeting when we're going to finalize this and decide whether we're going to move it on or not. So I think we ought to slow down, make sure we have all of the amendments identified so we're clear on what we're voting on. If this was coming back to us in a month or so and we'd have a chance to look at those conceptual amendments and see if we're still comfortable with how they played out, I'd have a little different feel. But I think today we need to make sure we're very clear on what these amendments are.
So, Mr. Fuller, if we were to take a quick break, would you be able to pencil out what you described to us on page 3?
So, Mr. Chairman, if you want it written, I could try to throw that together. Otherwise, Mr. Chairman, I'll just walk through the bill right now and identify the changes.
Let's do it that way, and hopefully that will give comfort. I think the co-chairman makes a good point. I don't want to run off and leave anybody. So if you would take that up for us,
All right,
Mr. Fuller, and give us an idea of what we're looking at.
So walking through this, Mr. Chairman, page 2 after line 8, as used in this article, law enforcement means the sheriff or a municipal peace officer. Then page 3, line 17, delete the sheriff, insert from law enforcement. Page 5, line 18, delete the sheriff, insert law enforcement. Then page 8, line 1, delete the sheriff, insert law enforcement. Page 8, line 15, delete the sheriff and insert law enforcement. And then, Mr. Chairman, page 9 is where things will start getting a little trickier because I think you have to leave, given the note about notification, so it would say, so I'm reading page 9, line 10. Upon verification, the sheriff shall, without delay, service notice to immediately vacating. And then I would probably put a period on page 9, line 13 after dwelling. Then a new sentence would read, upon service of notice, law enforcement shall put the owner in possession of the residential dwelling. Then page 9, line 17, delete the sheriff and insert law enforcement. And then page 9, lines 20, 21, delete the sheriff, insert law enforcement. Page 11, line 4, given, the sheriff would be the one serving process, that would remain unchanged. And then page 11, line 7, similarly, since the sheriff is serving notice, that remains. But then page 11, line 9, the owner may request that law enforcement stand by. And then page 11, line 13, and again on line 15, delete the sheriff, insert law enforcement. And Mr. Chairman, just as an aside, I believe that would address the question Representative Rodriguez-Williams raised concerning that ability to charge that hourly fee for that service. Then page 11, line 17, delete the sheriff or the sheriff's deputies and insert law enforcement. Then page 13, line 1, I would delete of the sheriff and just say the authority of any peace officer to arrest. And then, Mr. Chairman, I believe that would be the extent of that amendment.
That is well done on the fly, Mr. Fuller. Yeah. Does everybody understand? Go ahead, Representative Chestick.
I didn't mean to interrupt your question. I have a discussion of the amendment.
That's okay. That's where I was leading anyway. So go ahead, Representative.
Okay, thank you, Mr. Chairman. I think I'm going to be a no on the amendment, primarily because I think it's exacerbating a problem that I have with the bill in total. I don't like the bill in total because I don't like having sheriffs or having law enforcement officers serve as judge, jury, and executioner. And this bill in total puts the sheriff in the position of being the judge, has to evaluate the legal rights of individuals based on very brief notification, very brief investigations, and having the sheriff do that is problematic to me. Having the sheriff and other law enforcement officers is more problematic to me. So I think that this amendment makes it worse. The problem I have with the bill, this amendment makes that problem worse, and therefore I'm going to have to be a no vote on this amendment.
Okay, thank you, Representative. Any further discussion on the amendment? All in favor of the amendment, please say aye. Aye. All opposed, no. No. The amendment has passed. We are back on the bill. We were on page 3. Anything further on page 3? On page 4, there are a couple of considerations that your working group included in the draft comments. Anything on page 4? Representative Craigo, go ahead.
I got 2 proposed amendments. I'll do them separately if that's okay. Taking some advice from one of the people who testified to us on line 19, between the word no and pending, insert the word known.
And seconded by Representative Oakley. Does everybody understand the proposed amendment on line 19, page 4? All in favor of that amendment, say aye. Aye. Any opposed, no. That amendment has passed. Back to it, Representative Craigo.
And then the second one, Mr. Chairman, I guess just for the purposes of discussion, because I think we ought to talk about it a little bit, it would be to strike lines 1 through 3 on page 4.
The motion is to strike lines 1 through 3. That too has been seconded by Representative Oakley. Thank you. Discussion on that one.
So, Mr. Chairman, in our working group, we talked about this particular provision, and one of my concerns with it was you can get us in a situation where the property owner doesn't have the ability, or it would be dangerous for the property owner to go to the door and tell someone they have to get out. And one of the other requirements under this is that the sheriff since we've changed it now, any law enforcement officer in the county has to ask the person politely to leave and give them the opportunity. If they don't, then the process continues. I'm just a little bit, I don't see the necessity for the duplicity of that, because it's a little bit different than the trespass. We're not treating this as the same same procedure under trespass. And so I know based on previous testimony we heard at our prior meeting that particular person was brave enough to go ask him to leave, but some people shouldn't be brave enough to go ask him to leave. I think there could be some situations where that ends poorly. And so that's why I thought we should at least have the discussion about it. If it stays in, doesn't, I don't know if it's a deal killer for me, but I thought we should talk about it.
I think it's very appropriate. Thank you, Representative. Representative Oakley.
Thank you, Mr. Chairman. I just will agree with what Representative Craigo said. And I think one of the keys, again, here that we just keep going back to is that this is the idea, the concept, and the language that comes from eviction. And this is not about eviction. So this is about the owner having to give somebody notice that they have to leave. These are people who never had a right to be there, who are squatting. And so putting this, a lot of times like in law enforcement, you don't pit the person against each other. You don't have the victim go tell the person who's done something to them what they have to do. And that in essence is what this does. So removing this kind of, again, gets away from this concept that this is some sort of tenant that has the right to a notice. So, so I think it's befitting of what this bill is really trying to do.
Thank you. Further discussion on the amendment. Does everybody understand the amendment? You ready for the question? All in favor of striking the language lines 1 through 3 on page 4, say aye.
Aye.
Any opposed, no. That amendment has passed. Anything further on page 4? I would call attention to the immediate family member language at the bottom of page 4. We did touch on that. Let's go to page 5. And that's line 13. That goes directly to what I just alluded to, which is, do we wish to in any way add language which would help people understand who a family member is? Representative Craigo.
Thank you, Mr. Chairman. So on line 13, page 5, I'm sure Mr. Fuller can wordsmith this better, but my proposal would be to add the language after the word owner, add the language as defined in WS 9-1-701 AV.
The reference to that statute, do you understand? I'm sure, Mr. Fuller, where?
Yep, so Mr. Chairman, that's the language in the staff comment on the bottom of page 4. So it would be defined as spouse, child, or parent. And Mr. Chairman, if well taken, I would just add that as a definition on page 2.
Okay. Does that make sense, everyone? Want to make sure everybody's following that suggested amendment? All in favor of that amendment, please say aye.
Aye.
Any opposed, no? Okay, that one has passed. Anything further on page 5, Mr. Co-Chairman?
Make a motion. Mr. Co-Chairman, thank you. I'd make a motion that we strike the language in lines 2 through 5 regarding the open to the public language. I don't think we heard testimony that that was needed.
Seconded, Representative Nemec, thank you. Moved and seconded that we strike the language on lines 2 through 5, page 5. Any discussion? All in favor of the motion, please say aye.
Aye.
Any opposed, no? That motion has carried to strike that language. Anything on page? Representative Rodriguez-Williams, are you still on page 5? Yes, sir. Okay, let's stay on 5.
Thank you, Mr. Chairman. So on page 5, lines 7 through 8, I guess this is more discussion. Earlier, Representative Oakley, we passed an amendment on page 2, line 20, to remove is no longer authorized. And I'm not sure if this would be like a conforming to that amendment, or if this is totally separate, where they talk about or former tenant pursuant to.
Mr. Fuller, can you help us
Yeah,
with that?
so
Thank you.
Mr. Chairman, Representative Rodriguez-Williams, I think because this paragraph is in the bill now, you would not want to say an unauthorized person is someone who was formerly authorized. Because if someone was formerly authorized, then the owner would not be able to avail themselves of this process. If it's a former tenant, they would have to go through, the eviction, forcible entry detainer process. So that amendment was in response to the addition of this in there. That was my oversight for not catching that after the working group considered the bill.
Does that help, Representative? Okay. Okay, so everybody good on that? Okay, thank you, Representative. Now let's go to page 6.
And Mr. Chairman, here
Go ahead,
I would
Mr.
just
Fuller.
note, given the previous actions of the committee, page 6, lines 11 through 14, I would see that as a conforming amendment to delete that. That's the owner directed the person to leave. Then page 6, line 21 would be another place in light of adding known. That would be a place to add known. And then page 7, lines 2 through 5, that would be a paragraph for deletion as well, given the previous actions of the committee.
Does everybody understand what Mr. Fuller just described? Okay, thank you for that clarification, Mr. Fuller. And that takes us over to page 7. Anything at the bottom of page 7? Representative Chestick, and then we'll go to Representative Crago.
Still back on page 6, I think we have to deal with the purchase language on line 5, because people who have legal rights to occupy property may not own the property, may have it on a long-term lease or they've inherited it, there's other ways that they have legal title to that. So the date on which the residential dwelling was acquired by the owner might be, is that the best language? I think acquired is probably the best language for instead of purchased.
Okay. Representative Chestick, the motion is to strike purchased and insert the word acquired. Do I have a second by Representative Provenza? So Representative, I would only say there was also some discussion about the verbiage, the date at the beginning of that sentence. I can't remember what our realtors suggested on that front, if anything, but go ahead, Representative Provenza.
Mr. Chairman, I think part of the discussion and what my question was is if you remove that language and you have someone who's acquired property, but there's a tenant there's someone that resided in that home before that acquirement of that property, they should have right to the eviction process and not fall under this category. So I have heartburn about removing the date. I think there'll be paperwork and it'll be a small fraction of cases, right? But I just want to make sure we don't accidentally, with these folks that are living somewhere that just got bought.
No, that's helpful. Thank you, Representative, for helping me remember that was in relation to somebody already being in the facility when it's acquired. So does everybody understand the motion? Any further discussion? All in favor of the motion on page 6, please say aye. Aye. Any opposed, no. That motion has carried. Anything else on page 6? Thank you, Representative Chestick, for catching that one. And so we're over on page 7. Remember, 2 through 5 have been deleted from the bill. Anything at the bottom of page 7? Page 8. Representative Prego.
I really hate to do this, but go back to page 7.
You're taking us back to page 7?
Yes, sir. Apologize. Lines 7 through 10, and something Representative Provenza just brought up, and I think we at least need to talk about it. If you read that language, it says the unauthorized person is not a current or former tenant pursuant to a written or oral rental or lease agreement authorized by the owner or the owner's authorized agent. So the circumstance where she was talking about property changes hands, that language would not necessarily apply, even though I think the intent is that it would apply to any lease agreement, so long it was a valid lease agreement, right? So you have a circumstance where a tenant has leased a piece of property for a year, mid-year, the property changes ownership. That particular language, because it was a previous owner and not the current owner, wouldn't necessarily apply. And I don't know what to do about it, but we can think about it between now and when we're done talking about the bill, but there's a loophole there.
It doesn't seem to be a big loophole to me, but maybe I'm not fully understanding. Representative Provenza, comments?
I was just looking at Mr. Fuller, excited.
Oh, Mr. Fuller, thank you. We'd love to hear from you on this issue.
Yeah, high praise, Mr. Chairman. So, Mr. Chairman, I think maybe, one consideration there would be for that particular paragraph by the owner, the owner's predecessor, or the owner's authorized agent, if there's a desire to do that. And then it would be again on page 7, line 9, same concept.
Insert the language owner's predecessor. I think I understand that now. Representative Provenza, does that cover the base?
I think so, Mr. Chairman.
Okay, does everybody understand that one? All in favor of the motion? I had a second on that, didn't we? I think you made the motion, Representative Craigo, and a second by Senator Cooper. All in favor of the motion, say aye. Aye. Any opposed, no. That motion has carried. And now we're back on the bottom of page 7. Are we good? Thank you, Representative Craigo, for catching that one. Page 8. We're over onto page 9. And Representative Craigo.
Thank you, Mr. Chairman. So I would move to add the language at the top of page 9 with one minor addition. So at the end of the first clause, after the word dwelling on line 3, I would add the language, or is entitled to relief under this section. So it would read, if the sheriff is unable to verify that the person who submitted the complaint is the record owner of the residential dwelling or is entitled to relief under this section, the sheriff shall have no obligation and to serve notice and vacate the residential dwelling as provided in subsection D of this section.
Mr. Fuller, did you get that? Okay, I have a motion seconded by Representative Oakley. This proposed amendment goes in on line 3, page 9. Mr. Co-Chairman.
So, page 3, line 9, page 3, are we back to page 3? Or page 9,
Line 3, page 9, my apologies. After the words residential dwelling, that's where the proposed amendment would go in.
Okay, that's in the staff comment.
That is in the staff comments, or is entitled to relief under this section.
Okay, so my question is, do we want or and? That they're the owner of their dwelling and they're entitled to relief?
Representative?
Yeah, I believe that's a very friendly amendment. Thank you.
I thought, though, Representative, and maybe I'm just riding a slower horse, I kind of thought that using the word or would then qualify someone who is a subsequent owner. Maybe and's okay. Is the record owner of the residential dwelling or is entitled. Would there be any case where the record owner or someone subsequent to that would not be entitled to relief?
So I don't think so, Mr. Chairman, and previous in the paragraph. So right, this is actually this is going to go in on line 18, page 8. It's going to go and be part of that other paragraph. And it requires both, right? It says upon receipt of a complaint under this section, law enforcement shall verify that the person who submitted the complaint is the record owner of the residential dwelling or the authorized agent of the owner, and that the person is entitled to relief. So I think the co-chairman has a very good amendment to the amendment.
Okay, so that proposed amendment is and is entitled to relief under this section. Any further discussion on the amendment? All in favor of the amendment, say aye. Aye. Any opposed, no. That amendment has passed. We are back on page 9. And now over to page 10. Mr. Co-Chairman.
Thank you, Mr. Co-Chairman. So I don't want to make a motion yet, but I just want to explain the intent here of page 10 and see if the committee has any interest in maybe going down this path. The idea here was twofold. Number one, to flip the burden from the legal burden here from the property owner to the squatter. That if the squatter wanted to contest this action, it would be up to the squatter to file any action in the court within 72 hours. But what I was looking for here was an opportunity for the person who might feel like they were unjustly being removed from the property to have an opportunity for due process. But that would be on their responsibility to get down to and file that petition. And if they did so, then it would allow, I think Representative Chestic's concern, for a third-party review by the judicial branch to see if there's any merits. You know, if the occupant of the property comes forward and says, hey, I am a prior tenant, I do have some legal standing here, that you could get that before a judicial officer for that determination. But I'm thinking in the vast majority of these cases, the tenants don't do that. You know, if they're squatters, right? They're not doing that. They're just, they just say, no, I don't have to leave. And they put that all onto the property owner to file that litigation to get them removed and go through all those hoops. Where what I'm thinking along on page 10 is that if the property owner goes through all this process, that then the occupant of the property who feels that they are lawfully there can have some due process. So that's the idea here, but it's conceptual, and I'd be open to any comment from the committee.
So, committee, I was kind of intrigued by this when the co-chairman showed me for the first time. I kind of like the idea of flipping the coin, and you know, whoever's inhabiting the dwelling, if they really feel wronged, this would give that 72 hours of due process, and allow them to at least get a judge's stay if that's what they're seeking. Mr. Co-Chairman.
So we just recently had this case that was in the news where law enforcement removed somebody with a forcible eviction, right? And they were doing so under a belief that there was a power of attorney that gave this person authority. They go in there, they yank this person out, and now there's a claim, and the court recognized after a court hearing that the power of attorney wasn't validly in place. And so now there's civil litigation involved. So that's the kind of thing that I think that if we allow that individual who says, hey, this is not a valid power of attorney, or this is not valid in some other way, I have an opportunity to seek legal redress before the sheriff feels compelled to physically remove me from the property.
Representative Oakley.
Thank you, Mr. Chairman. I'm not set on it, but I mean, my concern about this is that yet again, we're going back to tenant and eviction sort of concepts, and also even scenarios that we're using to back it up. Before we get this far, it's supposed to be verified that the owner is there, they own the property, and that this person didn't formerly or currently have any right to be there. This is only for squatters who have not had that right. And I mean, I'm not saying that, you know, that it's perfect, but it is a different set that we're talking about. So it should be a very minimal, if at all, that there would be a mistake in this sort of realm, that, you know, that it was the wrong owner, things like that, because that goes back to that they were a former tenant, or that they had, this is specifically for the situation where that person will not be able to, the owner can say, this person has never had a legal right. Then we go, now we're switching it to sort of more this civil process, 72 hours, things like that, which in this instance, to me, the danger possibly of that person or those people damaging that property of which they've never had a legal right to be is a bigger danger than possibly this, finding out they had a legal right. We are trying to get to a subset where we clearly know they never had a legal right. And then we're giving them 72 hours to trash the place. I think that's a bigger danger. And for me, if we were even to go with a time limit, then I would limit it at 24 or something. That it's, because again, this whole process is that we've verified that this person did not and never has had a right to be there.
Thank you, Representative Oakley. Let's go to Representative Craigo and then back to Representative Provenza.
Just to follow up, Mr. Chairman, on Representative Oakley's comments, the way the bill's structured now, and as I understand what the process would be, right? If there is someone that has a right to be there, they're going to tell law enforcement. They're going to say, hey, I have this, or I've been living in this house for 6 months pursuant to an oral lease. Here's, I've been writing checks to stay there, and law enforcement's not going to be able to verify that they're not supposed to be there. So then we shift processes, and then we do go to an FED, which is similar to the proposed amendment. I have the same concerns that Representative Oakley does, is that what we're going to do is people that aren't allowed to be there are going to say, yeah, I'm allowed to be here. And they'll know they have 3 days to sit there. They'll wait the 3 days, and then they'll be gone. And in the meantime, who knows what they can do to the property. I too am concerned about giving them additional time to be in the property when there's no way they have the right to be there. And so they have 72 hours. We can't do anything to them for 72 hours. If they actually have a right, they're going to tell law enforcement up front, hey, I'm entitled to be here, and they'll give some sort of documentation of that one way or the other, whether it's a check that they've written or whatnot. I don't know. I'm just probably not in favor of the conceptual amendment.
Representative Provenza.
Thank you, Mr. Chairman. To the good co-chairman's points, I have concerns as well, but I think it's because this bill makes this issue confusing. Law enforcement came to us and said, we're already dealing with this with our trespass law. We have a process in place. And we also have the eviction issue in place. So you have 2 prongs that law enforcement is able to use and execute, and they're not struggling except for maybe one agency. And so now we're here with a third option, which is muddled at best. And now we're going to ask law enforcement to get involved in that, when I think it was pretty clear that at best they have heartburn. So I appreciate the concerns, and I don't know how I'm going to vote on the amendment, Mr. Chairman. I really don't. Because
Just for clarification, we don't have an amendment on the floor.
Okay, well, I'm saying if he were to bring it, right? The conceptual understanding of this, because I do think, particularly because we're expanding this to now municipal officers as well, who aren't used to dealing with the eviction process. And we're looking at potential, litigation. I think that was one of the concerns from law enforcement, was what about the negligence portion, and how am I supposed to determine all this? And we've done good work today, committee, on cleaning up this bill, but golly gee, it used to mean something that bill wasn't ready for prime time, and sure isn't now.
Mr. Co-Chairman, anything for, Representative Chesty, go ahead.
If I could just jump in to support the concept of an amendment if one were to be proposed. I do think that it does relieve some of my heartburn on the larger bill if we were to have the 72-hour waiting period. Whether or not somebody has a legal right is quintessentially the function of a judge. It's not the law enforcement to determine, yes, you're right, you're wrong. That's a judge's function. And I think anything we can do, my primary problem with the whole bill is the shortcuts through due process. And adding that 72-hour waiting period, I think, it makes it less bad. It's still not, I'm not sure I'll vote on the bill. If this amendment passes, I don't know if I would still vote for the bill or not, but it would make it better. So I would be in support of some kind of a waiting period.
Okay, anything further? Okay, now back to the co-chairman for any final thoughts or
Yeah,
actions that you
the
might want to
discussion has
propose?
given me pause, and I'm not going to propose an amendment. Somebody else may if they wish, but I think that the risk of damaging to the property is there. My hope there was that maybe this might minimize the opportunity for liability to the law enforcement agency, but I think we've mitigated that in other aspects of the bill to the point where the potential for those 72 hours to allow someone to do further damage to the property, yeah, probably makes it unworkable. And frankly, I don't know if you could actually get a court to review this in 72 hours and issue a stay and all that stuff on a practical side. So I'm not going to make a motion.
Okay, let's move on through if we can and keep working the bill. Representative Chesty.
Thank you, Mr. Chairman. I will make the proposed, I will move as an amendment staff comment that's on page 10 to add the 72-hour waiting period to see where this goes.
Okay, there's a motion on the floor, seconded by Representative Provenza. Any further discussion? Everyone understand the proposed amendment? Okay, all in favor of the amendment, please say aye. Aye. All opposed, say no. No. That amendment has failed. We are on page 11, committee, as we're working 002, working draft point 7, page 11, page 12. Anything on page 13? Page 14. We have new language on page 15.
Yeah, 15.
Mr. Co-Chairman.
Thank you, Mr. Co-Chairman. So I do have some heartburn with the language lines 1 through 7 on page 15. This whole bill's about trespassing within residential property. But if you read that paragraph, it says that anyone who trespasses, detains, occupies, or trespasses upon property and who knowingly defaces, injures, or destroys a property, regardless of value, is a 10-year felony. So if a trespasser steps on my tulips and crushes my tulips, this paragraph would make that a 10-year felony.
Well, you should tiptoe. I mean, that's...
Don't make me sing, Mr. Chairman. So.
I apologize, Mr. Co-Chairman. Go ahead.
My proposed amendment is that after the word upon, or before the word upon, trespasses within a residential dwelling or residential property, whatever the terminology we used previously in the bill. So we're not talking about somebody walking across the prairie or into your backyard, but somebody who's actually trespassing within the residential dwelling. Mr. Fuller?
So, Mr. Fuller, talk to us about this paragraph.
So, yeah, I think, Mr. Chairman, it's been described. I mean, it would be a new carve out from the current property destruction offense, you know, and would, as currently drafted, apply to property regardless of the nature of that property. Mr. Chairman, I said, you know, my suggestion would be to say maybe delete, like, so page 15, line 4, delete property and say trespasses upon a residential dwelling as defined in 121-1401A2, and that's page 2, the definition on page 2, line 13. So that would tie it back to that definition in the bill.
The co-chairman's indicated that that works. So, committee, does everybody understand what the co-chairman's motion is? Do I have a second on that motion? Seconded by Senator Cooper. Everybody understand that we're specifying residential property on line 4, page 15. Representative Provenza.
Thank you, Mr. Chairman. I just have a question for Mr. Fuller. Are we sure that in our statutes, we don't already have punishment for destruction of property? I mean, do we need this section at all?
Mr. Fuller?
If I could, Mr. Co-Chairman.
Go ahead, Mr. Co-Chairman, while Mr. Fuller.
Yeah, so we do, if the property value is $1,000 or more. And so what this language would do is pump it up to a 10-year felony for that property less than $1,000. So if you do $5 worth of damage while you're squatting in somebody's house, that's now a 10-year felony. Where before, under existing statutes, it'd have to be at least $1,000 in damage before you had that felony.
Mr. Fuller, I'll let you jump in, and then I'll go to Representative Oakley.
Yeah, Mr. Chairman, nothing else to add. I mean, this is a carve out from that current $1,000 threshold, and says if you are trespassing upon property and you knowingly destroy that property, the monetary value is irrelevant. It would be that felony. And Mr. Chairman, I think it's within the committee's decision to decide how to proceed.
Representative Oakley.
Thank you, Mr. Chairman. I don't have a strong feeling on this either way. Clearly, the idea, though, being along with this, that if while you're doing it, you knowingly destroy my property, let's say, you break out a window, you do you could do something to the house that was less than $1,000, but by virtue of you being this squatter, it's available to charge as a felony. Like I say, there are ways, if it's over $1,000, you could already do it regardless of, if you were found to be this trespasser, squatter, or of course, if it's under any property destruction. Again, I will push back a little on tiptoeing through the tulips, because it is knowingly defacing. But so just a policy decision on whether we want to have this enhancement regardless of value if they knowingly damage the property.
So my question, committee, is whether or not we even need the language proposed in 63201 in this bill. If anyone can help me around that one. Representative Provenza.
Mr. Chairman, yeah, I think probably we don't. I mean, I get, the tiptoeing the tulips is not necessarily the issue, but I mean, I don't know if anybody's ever stayed in Airbnb, but the cleaning fees are $750 a night. So not quite literally, but it's not far from turning somebody into a felon. And I think that, let's look at what what's often going to be the issue with a squatter. Somebody who might be dealing with mental health issues, substance issues. Do we want to throw that person in prison for 10 years for people that are already, talk about kicking people while they're down. So I think maybe we take out the whole section, but I'll let the chairman decide. We can vote on this amendment first.
Mr. Chairman.
Senator Case.
Thank you, Mr. Chairman. I kind of think about this in a different way. And I want to call your attention to our statute about burglary. Burglary is a very serious crime. There's no misdemeanor level of burglary. And that's, it goes way back to Middle Ages where people broke into houses. It's called housebreaking, and very, very serious crime. Burglary is still a crime, a serious crime, because the idea is you could have someone that's come into your place and they encounter a family member, and then that's a very dangerous situation. And I'm inclined to just think, wow, in a burglary situation, I believe it's a 10-year felony, could be for burglary. And this, they may have taken something. They certainly they in a way took something from you by squatting in your place. But there's that dangerous possibility of encountering another person and having that escalate. So these people have I go back to Representative Oakley, said time and time again, these aren't people with a right to be here. And if there is some way that there is a right to be here that was all mixed up, That'll get sorted out in the judicial process. This is a dangerous situation, to have people in a house confronting other people, so I vote for the enhancements.
Appreciate that perspective, Senator. All of that has helped. Representative, thank you. I appreciate that. Anything further on, I think we do still have we did away with the motion, did we not? We haven't. We still have a motion on the floor regarding line 4 on page 15. Mr. Co-Chairman, go ahead.
Just a final comment. So this language will still provide the enhancement, provided the damage is done to the residential dwelling. But if the damage is to the tulips in the backyard on the way to the dwelling, we're not going to make that a 10-year felony. But if they do damage, they're poking holes in the sheetrock, they're yanking out some of the copper pipe or whatever, that would qualify for the 10-year enhancement, even if it doesn't reach the $1,000 threshold. So that's what the amendment does.
Okay. All in favor of the motion on line 4, say aye.
Aye.
Any opposed, no. That motion has carried. We are almost there, folks. This is, it's been good work. I know it sometimes can seem tedious, but we're almost to the end of the bill. Representative Provenza.
Mr. Chairman, I think we should make this effective July 1st, 2026.
Okay, is that a motion?
Yep.
Seconded by Representative Chestick. Any discussion?
I just like to say, Mr. Chairman,
Okay.
I think that this has more substantial changes to how law enforcement does their jobs and their understanding of this than we might appreciate right now. And there might need to be training and other things that I think maybe we want more time on.
Anything further? Okay, all in favor of the motion, say aye.
Aye.
Those opposed, no.
No.
That motion fails. We are to the end of the bill. Anything further on the bill? Representative Craigo.
Thank you, Mr. Chairman. So this goes back to my question regarding service of notice and whether we can just notify versus serve notice. And I have a proposed amendment, and I'll throw it out there, see if we get a second, and then we can talk about whether it's a good idea or not. So on page 9, we'll start at line 11, and the word sheriff becomes law enforcement. So upon verification under subsection C of this section, law enforcement shall without delay, then we strike serve a notice to immediately vacate and insert the word notify to immediately vacate all unauthorized persons occupying the residential dwelling.
Thank you, Representative. Makes sense to me. Seconded by Representative Neming.
And I actually have one more, sorry. So we also have to go to page 11. Line 7, and this would be conforming. So on line 7, strike the words "the sheriff serves the notice," and it would be after law enforcement notifies the unauthorized person would be inserted. And I think those two would conform. Mr. Fuller, I'm sure, can get it closer to right, but that would be the conceptual. I'll make that motion, see if we can get a second, and then talk about it.
Let's, what I'm going to do is, that's all one motion by the representative. Representative Neming, are you good with your second? Okay, so that takes care of it. We, does everyone understand, and Mr. Fuller, did you get that?
Yep, so Mr. Chairman, one question would be page 11, lines 4 and 5, the disposition of that language for the fee for service of process.
Sorry, Mr. Chairman, that should have been stricken as well as part of the amendment.
Okay. Does everybody understand? Mr. Co-Chairman?
Let's just do it and make sure.
Oh, really?
Part of the motion.
Yeah, that's friendly and part of the motion. Mr. Co-Chairman, and then I'll go to Representative Chestic.
Thank you, Mr. Co-Chairman. I'm not sure I heard Mr. Fuller, but on line 14, page 9, there's a reference to service as well. Do we want to change that to notification? Make that part of the motion? Okay.
Representative Chestic.
Thank you, Mr. Chairman. Mr. Fuller might be able to clarify this for me, but I thought when we went through, we did that amendment on the fly. I believe that on page 9, line 11, that sheriff did not change. That was actually the concept of that amendment that we passed was that the sheriff is still going to do the service of process. So that sheriff, and so the current amendment assumes that sheriff has been changed to law enforcement. I don't think it has. Is that correct, Mr. Fuller?
Mr. Chairman, Representative Chestic, I understood it as part of the amendment that Representative Crago read, that now it would change to read law enforcement shall without delay notify the unauthorized occupant to immediately vacate.
Previously, it was left to sheriff. Anything further, committee? Go ahead, Representative Crago.
Yeah, and I know it's unorthodox, but I wouldn't mind having the opinion of our law enforcement folks in the room, because we didn't really talk about this when they were up here. I mean, we talked about the problems with it, but not whether this idea is better or worse. I mean, I'd appreciate their opinion if the chairman would allow it.
I absolutely will. Thank you, Representative. Glad to do it. Mr. Thompson, thank you for coming up. Any heartburn over what we're suggesting right now?
Mr. Chairman, thank you. Alan Thompson with WASCOP. As I'm looking at this, I might have a concern with page 11. That's a different statute. That's the existing process, I believe, for fees for notice to vacate. So if I would be hesitant, I would ask the committee to take a deeper look at 121-1403 and make sure we're not taking fees away from an existing practice that we do already, our sheriffs do already, and removing language related specifically to the sheriff in that statute, because that'll have an effect on the existing service of 3-day notice and fees for process.
Thank you, Mr. Thompson. So, Mr. Fuller, any thoughts on that?
Yeah, so Mr. Chairman, by deleting page 11, lines 4 and 5, all that would do is delete the ability to collect a fee for the notice under this bill draft. It does not in any way change the fees that are authorized to be assessed under 183608.
Okay, thank you. Appreciate it.
Thank you.
Mr. Thompson, anything else? Representative, any questions for the chiefs and sheriffs?
No, Mr. Chairman, I think Mr. Thompson said, other than we're that concerned that they weren't worried about the language change. Obviously, if after we get the final bill draft out, they have questions, we'll work on it during session and make sure we get it right. Just think this simplifies the process and for both sections of law enforcement, sheriff and our municipal police departments, because then they don't necessarily have to work together to get this process done.
Okay, thank you, Mr. Thompson. Thank you, Representative. Are we ready for the question on the amendment? All in favor of the amendment, say aye. Aye. Any opposed, no. That amendment on pages 9 and 11 passes. Committee, anything further on draft point 7 of 002? Anything further? Representative Chestic.
Thank you, Mr. Chairman. First, I want to thank the working group for the work they did on this bill. I think it improved it significantly, and the work we did today, I think, improved the bill significantly. But I still have concerns, and I don't think the improvements have not gotten it to the point where I think I'm able to support the bill. The intent of this bill is apparently to speed up the process of getting rid of squatters, and I appreciate that's a good goal. I understand why people want to do that, but the quickest way for a shortcut is to go right through due process. And I still have due process concerns about this bill. The idea that there is an existing remedy, I think, I like limiting this bill to squatters. That's perfect. That's a good thing. That's one of the big improvements we've made to this bill. But there's still trespass, and there's still laws that I think are sufficient. And those remedies incorporate due process and have real judges deciding who has rights and who doesn't have rights. And I don't like putting on law enforcement officers the decision whether somebody has a right or not, who's right or who's wrong. That's not a law enforcement function, that's a judge's function. So for that reason, I'm still going to have to vote no on the bill.
Okay, thank you, Representative. Anything else? Okay, roll call on 002, please.
Mr. Chairman, this is a roll call vote for 25 LSO2 residential property removal of unlawful occupant as amended. Senator Case? Aye. Senator Cooper?
Aye.
Senator Furphy?
Aye.
Senator Schuler? Aye. Representative Chestick?
No.
Representative Crago? Aye. Representative Haroldson?
No.
Representative Jennings? No. Representative Nemec? Aye. Representative Oakley? Aye. Representative Provenza?
No.
Representative Rodriguez-Williams?
Aye.
Co-Chairman Washit?
Aye.
Chairman Landon?
Aye.
Mr. Chairman, we have 10 ayes, 4 noes.
Okay, so LSO 002 will go to the session beginning in January. Thank you for your efforts on that bill, committee. Still some work to do perhaps, but glad we're able to continue on. Committee, we're not going to take a break. Please feel free to get a break on your own real quickly. We're going to keep charging because we're a little behind, and my apologies to those who've been waiting on a couple of other bills. Mr. Fuller, would you go right into a description of use of fraudulent documents to wrongfully possess property, 131?
Yep, Mr. Chairman, you should have draft 0.5. It's 2-02 in the online meeting materials. This is a bill draft that the committee considered in September, forwarded consideration to this meeting. The draft is unchanged from the version that the committee looked at in September. This bill draft would create the offense of using fraudulent documents to gain or remain in possession of property. The staff comment on pages 2 and 3, back in June when the committee first requested the bill draft, there was a question of similar laws that involve the use of a false or fraudulent document to gain possession of property. Those examples are provided in that staff comment. Then moving on to page 3, line 30 are definitions that would be applicable to this offense. And first is a definition of document, which means a writing, whether in physical, electronic, or another form. And then the staff comment on the top of page 4 notes that writing is defined already in this article. And it would mean, I think primarily for purposes of this bill draft, it would mean printing or any other method of recording information. So it would be, so in the use of the term document, it's really any sort of printing or method of recording information that's in physical, electronic, or another form. Then page 4, line 19 defines property as residential real property that's improved by a dwelling, structure, or other building. Then page 4, line 22, a person is guilty of a felony, punishable by imprisonment for up to 10 years, a fine up to $10,000 or both, if the person intentionally uses a document that the person knows or reasonably should know is false or fraudulent to gain or remain in possession of property or to claim a right to property for which the person does not have a legal right to possess or claim a right. Then, Mr. Chairman, the staff comment on page 5 just notes that the penalty that's used in this new offense is the penalty provided for felony forgery and possession of forged writings. And that penalty is just really provided as a placeholder. It'll be up to the committee to decide what the appropriate penalty for this new offense would be. Then, Mr. Chairman, the staff comment goes on, this is page 5, line 18, to note that the committee may wish to consider this new offense in light of the consolidated theft statute, which is produced below in relevant part, and then also Wyoming's forgery statute, which is in the staff comment on page 6. With that, Mr. Chairman, happy to answer questions.
Okay, committee, questions of Mr. Fuller. We are on 131, working draft point 5, the fraudulent documents bill. Thank you, Mr. Fuller. Is there anyone who would like to testify today on 131? Anyone here remaining who would like to testify on this one? Mr. Thompson, go ahead, come forward. We need to decide if we're going to incorporate anything. Mr. Thompson, welcome back.
Mr. Chairman, sorry about the delay. I have a hard time with this microphone. Alan Thompson with Wascott, and this is a bill that appears to open up avenues for law enforcement to maybe easier opportunities for them to investigate those instances where someone is using fraudulent documents or altering documents to claim residency. And we haven't had any widespread discussion over this topic, so I have nothing to add or suggest other than the concept seems to be in line with our goals in the session of strengthening these protections for property owners and making sure that squatters are not afforded opportunities that they shouldn't otherwise have.
Go ahead, Mr. Co-Chair.
Mr. Thompson, do you see this bill draft as giving more authority than presently exists? When I looked at the language in the existing theft statute and the forgery statute, it seems like it largely covers it, that if someone, takes property by deception, right? And then uses or receives that property in a way to deprive the other person of its use, it sounds like that's already covered in the theft statute. So I'm curious if you see the new language contained in draft 131 as beneficial or simply redundant to existing authority that you have. Does a peace officer with this language have more ability to deal with these types of problems than they would without it?
Mr. Thompson, go ahead.
Yeah, Mr. Chairman, I'm not so sure that we have more ability to deal with it, but I think it lines it out easier to read in an easier to read format specific for this. Is it needed? It's a policy decision for the committee, but from a law enforcement standpoint and for property owners understanding law when they just Google it, outlining it specific to these circumstances, I don't think hurts.
Any other questions? Thank you, Mr. Thompson. Appreciate it.
Thank you.
Anybody else like to come forward and testify on 131? Larissa, do we have anyone online this morning on this bill? Okay, if there's nobody else that wants to come forward, we will close testimony on this bill. Committee, what's your pleasure on 131? What is your pleasure on 131? Okay, if there, Representative Crago moved the bill. Do I have a second? Seconded by Representative Oakley. Discussion. Are you ready for a roll call on it? Senator Cooper, you ready? You good? Okay, let's take roll on 131.
Mr. Chairman, this is a roll call vote for 25 LSO 131, use of fraudulent documents to wrongfully possess property. Senator Case? Senator Cooper? Aye. Senator Furphy?
No.
Senator Schuler? Aye. Representative Chestick? No. Representative Crago? Aye. Representative Haraldson?
Excused.
Representative Jennings? No. Representative Nemec? Aye. Representative Oakley? Aye. Representative Provenza? No. Representative Rodriguez-Williams,
No.
Co-Chairman Washit,
Aye.
Chairman Landon.
Aye.
Mr. Chairman, we have 8 ayes, 5 noes, 1 excused.
Okay, so committee, that bill has passed and we'll go on to the session. It feels an awful lot like a House bill, but we'll determine that at a later date, so. Okay, let's move on. I'm looking for Director Shannon. He'll be right back. Okay, good. We're going to move right on into the Department of Corrections Committee. And again, take a break when you need one. We're going to consider LSO 124, Restoration of Rights Amendments. And Mr. Fuller, are you set to explain this little bill to us?
Ready to go, Mr. Chairman. So 25 LSO 124, this is draft 0.8, 3-01 in the online meeting materials, Restoration of Rights Amendments. This is a bill draft that was based on suggestions from the Department of Corrections and would clarify that new convictions would void a previous restoration of rights for convicted felons and clarify notice requirements associated with the restoration of rights. After discussion in September concerning the ability and the appropriateness of restoring rights for a conviction that did not originate under Wyoming state law, there was a desire to move this bill draft forward and consider it with those changes in mind. So the staff comment on page 2 notes that there are 2 separate versions in this bill draft as it currently is drafted. So first, which I'll go through, the governor and the Department of Corrections are only authorized to restore rights of persons convicted of a felony under Wyoming state law. Then in a staff comment at the end of the bill, the governor and the Department of Corrections would be authorized to restore the rights of a person convicted of a felony under the laws of Wyoming or under the laws of another state. And when I finish going through the bill, Mr. Chairman, I'll note a Supreme Court case that considered this issue that might be relevant for the committee's consideration. So page 2, line 32, and Mr. Chairman, maybe one more note before I get started. Neither version would provide for the restoration of rights for a person convicted of a felony under federal law. So that concept has been removed entirely from consideration of, or from how the bill is drafted. So page 2, line 32 is just a conforming amendment to 111-102 to reference a subsection for the restoration of rights. Page 3, lines 7 and 8 is a conforming amendment to reference new subsections. And then lines 9 and 10, this is the subsection A that allows the governor to issue a certificate of restoration of rights. It strikes a reference to under the laws of a state or the United States. And new language later on in the bill will limit this to just Wyoming. The staff comment on the bottom of page 3 and the top of page 4 is just a reference to 610-106, which notes the rights that are lost upon a felony conviction. Page 4, line 12 is a conforming amendment to subsection B, which concerns the restoration of voting rights. Then page 4, line 24, the new language would provide that there's automatic issuance of a certificate of restoration of voting rights if before conviction the person had the right to vote or would have had the right to vote upon turning age 18. Page 5, line 5, this concerns, again, a subsection for the restoration of voting rights, striking the language within Wyoming. And that will be addressed later on in the bill draft. Page 5, line 20 strikes a reference to voting in subsection D and instead references subsections B, C, or F. B or C, again, are the voting rights. Subsection F is the restoration of all other rights. Moving on to page 6, similar concept, line 3, we're striking voting. And then page 6, lines 5 and 6, strike a reference to if the person was convicted in Wyoming. Page 6, lines 16 to 18 in the definition of violent felony, striking a reference to offenses that, if committed in another jurisdiction, would be a violent felony under Wyoming law. Page 6, lines 22 and 23, subsection F, which concerns the restoration of all other rights, a conforming amendment is added. Page 7, lines 18 and 19, similarly, another conforming amendment. Page 8, lines 2 through 5, a previous version of the bill draft had notice going to the Division of Criminal Investigation. This would still have notice going to the federal ATF. And the change here is just a clarifying change for the name. So it would be anytime rights are restored, notice would be given to ATF. And then page 8, line 10 would add a new paragraph that provides notice to the Division of Criminal Investigation. Page 8, line 13, this new subsection H was in the previous version of the bill and provides that if a person is convicted of a new felony under any law, then the certificate of restoration of rights is automatically void, and all rights that were previously restored by that certificate of restoration of rights is deemed, those rights are no longer deemed restored. Page 8, line 21, this is probably the key difference to the bill draft compared to the previous version. And it provides that a person shall only be eligible for a certificate of restoration of rights as follows. Page 9, the governor's restoration, so subsection A, is available if the person was convicted of a felony under the laws of Wyoming. And then page 9, line 5, under subsection B, C, and F, if the person was convicted of a nonviolent felony or nonviolent felonies arising out of the same occurrence under Wyoming state law. So in short, the governor's restorations would be available for any felony conviction under Wyoming law. The Department of Corrections restoration of voting rights under subsection B or C, or all other rights under subsection F would be for nonviolent felonies under Wyoming state law. Then the staff comment. Mr. Chairman, I won't go through the conforming changes. I would just go right to page 13. And this would, the key difference here is under this version, the governor, so page 13, line 38, the governor could restore rights of a person convicted of a felony under Wyoming state law or another state law. And then page 13, line 42, for purposes of the rights to possess a firearm, under subsection F, if the person was convicted of a nonviolent felony under the law of Wyoming. So it's kind of split. The governor would be able to restore under Wyoming law or another state's law. For firearms purposes, it would be under the laws of Wyoming. And then page 14, line 4, voting rights would be able to be restored by the Department of Corrections under Wyoming state law or another state law. And Mr. Chairman, just by way of conclusion, the case is Beecham versus United States. It's a 1994 case. And the upshot of that, of the Supreme Court's decision, is basically to say that the restoration of rights for a conviction has to be determined by the law, governing that conviction. So if it's federal law, it would have to be a federal restoration of rights. And this is specifically for purposes of federal law, 18 U.S.C. 922 G1, which precludes a person convicted of a felony from possessing a firearm. So the court has said, for purposes of that prohibition, we're going to look to the law of the state of conviction to determine the restoration of rights. So in other words, it would have to be restored to the right under federal law. It would have to be a federal restoration of rights for that to be effective. With that, Mr. Chairman, I know there's a lot going on in the bill draft. Happy to answer questions.
Thank you, Mr. Co-Chairman, and thank you, Mr. Fuller. Any questions of Mr. Fuller regarding the draft? Representative Harrelson.
Thank you, Mr. Chairman. Mr. Fuller, thank you. So that that case that you're talking about, did that have ramifications, or did that apply to state? So if a state were to be removing rights, could we restore, say, Colorado restoration of rights? So if a person got convicted in Colorado of a felony, lost rights in Colorado, could we restore those rights in Wyoming? And does that apply?
Mr. Fuller?
So, Mr. Chairman, Representative Haroldson, I think for, non-firearm rights, probably an open question. I think, under 18 USC 922, for purposes of that firearms, I think there'd be a real question whether we could, restore firearm rights for a person convicted of a felony under another state law.
Okay, anything else, committee? Mr. Director, do you guys want to come on up? We'd love to hear from you on this bill, and maybe a quick reminder, what brought us here in the first place, and our desire to continue to work this into the third meeting. So we can talk about all of those things, Director. Yeah.
Mr. Chairman, Co-Chairman, committee members, excuse me, I'm Dan Shannon with the Department of Corrections. To my right is Ellison Moore, Deputy Director for DCI, and thank you for having us today. Just a few comments of how we got here. I asked the committee during the interim if we would consider reviewing some changes possibly to 713-105, which became effective July 1st of 2023, so approximately 16 months ago. One concern that I had was submitting and approving certificates for individuals convicted on federal convictions, and what impact that would have on our citizens. So I think that's what brought us here today. If I may, the department recognizes that both of these draft bills, and I really believe the separation is on page 10, from page 10 forward, that both of these draft bills from 713-105 exclude individuals with federal convictions from having their rights restored. And I believe that's what brought us here today, Mr. Chairman. Under option one, the first option in the draft legislation provides the department with a process for restoring rights, as it has the same requirements for Wyoming convictions only, regardless of which rights being restored. The draft version also limits the scope of the statute to remain within Wyoming. So that type of change would ensure statutory authority would remain within the state. I do appreciate the hard work that Mr. Fuller did on this draft and the separation. And my understanding also, and I'll go into a little bit of data just very briefly, from the Beecham case, what it would provide an opportunity. So the example is if an individual is living in Nebraska, and which is what takes place now, and we restore the rights, and that person comes to Wyoming and goes back to Nebraska, that's a federal violation because they don't recognize as us restoring the rights from the state of the conviction. So if it was a Nebraska conviction, he comes here hunting, that person's still exposed from the feds. And I'm not here to dictate policy, but I think that's a huge exposure. Under option two, which, as I said on the bill, it's separation on page 10, it provides a pathway for individuals for out-of-state convictions to have their voting rights restored. However, it does not provide restoration of firearm rights. So how does that, it's my understanding this option provides individuals moving into Wyoming the same rights restored. And additionally, under this option, the practice of restored rights, as I said, except for firearms for individuals who live outside of Wyoming. So to have a little, for the committee to have a little understanding where we stand today, as I mentioned earlier, we've authorized 58 certificates for individuals with federal convictions. For those who are living in Wyoming of out-of-state convictions, so that would be a person that, say, is convicted in Montana, becomes a resident of Wyoming, we've authorized 54 certificates. For those living out of state with Wyoming convictions, it's been 147. And then we have 3 individuals that were not convicted in Wyoming nor living in Wyoming. So the separation between option 1 and 2, from my understanding, and I think Mr. Fuller was much more elegant with it. Option number 1 provides us to restore rights for individuals who were convicted in Wyoming and residing in Wyoming. No, I'm sorry, not convicted in Wyoming convictions only. The residence doesn't matter. And that is for firearms as well as other rights. Under option 2, it would, both of these exempt federal, but under option 2, it would exempt, my understanding is federal rights. So we wouldn't restore those federal convictions. We wouldn't restore firearms, but we would restore voting. So, Mr. Chairman, I'll stand for questions. That's my understanding of the proposed changes to the committee.
Okay, thank you, Director, and Deputy, thank you for being here too, and you're certainly welcome to weigh in or just be there for questions later. Okay. Committee questions. This is an important bill. I want to make sure we understand. Go ahead, Mr. Co-Chairman.
Thank you, Mr. Co-Chairman. So I asked you to send me a copy of the actual form that the department issues, and I think whichever way we go with this bill draft, my recommendation is that the document that's issued needs to be more explicit in bold text for the recipient of that certificate, that if they have other convictions, right, that the fact that Wyoming restored their rights for a Wyoming conviction, if they have a pre-existing conviction in another state, or they have a pre-existing federal conviction, that this restoration of rights doesn't affect those things. And I just think in fairness to our citizens who get notified that their rights have been restored, we need to be very explicit in that. And just ask you, what would it take to modify that form to make that type of explicit notification?
Go ahead, Director.
Mr. Chairman, Co-Chairman, it would take, I can modify that today if that's what the committee so chooses. With that being said, without the change of the current statute, I don't know how accurate that statement would be. With the changes, we could modify it immediately, and I'm willing to do so. That's guidance I've received from council, that under the current statute, we do authorize federal as well as other states, but I could change that pretty quick.
Let's go to Representative Jennings first, and then to Representative Harrelson.
Thank you, Mr. Chairman. Director, do you have a copy of this? On page 13, I have a question for you. At the end of that, on line 32, it shall be, so it's an assumption that it's going to be nullified or something like that. But how does this paragraph actually work? What's the mechanism? How do you find that out? How do you notify? I mean, it seems like it's going to require a background check.
Representative Jennings, whereabouts are you? I apologize.
Page 13, starting at line 27 through 33.
Okay, thank you. I had trouble hearing you.
Just how do you see that happening? Because it seems like this might open up a box here of having to, are you guys going to run the background check and something happens there?
Mr. Chairman, Representative Jennings, the answer to your question would be no. We run the background checks upon issuance of the certificate. We don't do background checks continuously or follow up with them. That's why it's on the presumption is on the individual who receives the certificate that it's null and void if they have another conviction.
Deputy Director Moore, do you want to weigh in on that one?
Yes, Chairman. Representative Jennings, currently the way we do it within the Division of Criminal Investigation, so we have the criminal history repository. So when we get a restoration of rights from the Department of Corrections, that restoration is noted on that specific case that the conviction was with. So when, say, a person goes to purchase a firearm and a federal background check is ran, the FBI, that goes through NICS. Nix runs the background check, they would see that restoration of rights tied to that felony. If there were any new disqualifiers after that, then they would see that they had a federal firearm disqualifier.
Okay, Representative Jennings, follow up?
Thank you, Mr. Chairman. So, but that would only apply like on gun purchase or something like that, but the rest of the restoration of rights would go away too, theoretically. And so somebody gets a restoration of rights in Wyoming, moves to Nebraska, there commits a, something that disqualifies them, but then they move back to Wyoming. I mean, how would you know? I mean, how would this work in real life?
Ms. Moore, go ahead.
Chairman, Representative Jennings. Currently, if we're talking firearms, that would still be discovered on a firearm background check, if a background check were done. If you're speaking to voting, that would be a question for the Secretary of State. We do push all of our criminal history data to the Secretary of State. So they also get information from Department of Corrections, so they know if someone had a restoration of rights. And then if we push a new felony conviction to them, then they know that that restoration is no longer in place.
Representative Harrelson.
Thank you. Just either one of you guys, just to clarify, or I guess maybe give me a refresher, as we were talking about the certificate that you received. So basically stating, this is restoring your Wyoming rights, but if you have other felonies, yada, yada. When you do the initial restoration, from what I remember, it is for a single nonviolent felon. So if they already had multiple felonies, they're already disqualified. Am I reading it? If I remember right from our initial discussions on this a couple of years ago, that would have been an automatic disqualifier, multiple convictions. So basically, they're getting a single conviction restoration, and as it currently sits in statute, it could be federal, another state, or the state of Wyoming. Am I correct in that?
Correct, Shannon?
Mr. Chairman, Representative Harrelson, you are correct on this, on the second assumption. It would be for a nonviolent first single offense unless it could be two offenses if it's within the same occurrence. So it would be for one event of nonviolent felonies.
Mr. Co-Chairman?
Thank you. So I guess the question comes up with misdemeanor domestic violence prohibited status, that would not trigger our reference to a single felony conviction, but they still may be a prohibited person federally, even though we restore their rights under a felony conviction in Wyoming for burglary or something. If they have a pre-existing domestic violence conviction from another state, would they be ineligible to get their rights restored on the gun rights in Wyoming?
Mr. Chairman, Mr. Co-Chairman, my understanding, they would receive the certificate, but they would also be in violation of the federal, yes.
Representative Jennings.
So I want to thank you, Mr. Chairman. I'd like to go back and visit this a little further and give you just a, conceptual idea. So somebody lives in Wyoming and they've committed a crime, they've gotten a restoration of rights, they move to South Dakota. The job doesn't work out, but while they're over there, they get something that is, similar, and they get that. Now, under our law, it says they've lost their rights, their voting rights. How does the Secretary of State determine that they are no longer eligible to vote? Does he then have to run a background check to pick that up? Because the second one, the disqualifier happened outside of state. But theoretically, they could come home, move back in to the basement with mama and vote. I'm just asking, I understand on the gun rights, the feds are going to pick that up and they're not going to be able to purchase a gun. But on the voting, how does the Secretary of State, how is this supposed to function in real life, that they know that they were disqualified by committing a crime out of state?
Deputy Director, how do we catch them?
Chairman, Representative Jennings, I'm not sure. That definitely is a question for the Secretary of State. I don't know what their process is to do background checks for voting purposes. I don't know what they do currently. I mean, how do they do that currently when someone registers to vote? I know how they get the information from us. I don't know how they get the information from other states currently.
Director Shannon, I think you had a thought on that.
Well, Mr. Chairman, Representative Jennings, I can't speak for the Secretary of State or their operations. In the event that we would revoke a certificate, the Secretary of State is notified. The onus of the responsibility is on the individual. That if he goes to Nebraska and then gets another crime, this certificate is no longer valid. And if he would go try and vote, it's committing a crime.
Mr. Co-Chairman.
Thank you. I still a little perplexed. So we have an individual, lives in Wyoming, has a nonviolent felony conviction in Wyoming. He also has a domestic violence conviction in Wyoming. Do we grant a restoration of rights for the felony conviction? And if we do we notify him that that does not offset the domestic violence prohibition? How's that work?
Mr. Chairman, Mr. Co-Chairman, I misspoke earlier. He would be eligible for the restoration of the other rights, but not the firearm rights in Wyoming.
And would it occur, thank you, Mr. Chairman, follow up, would it occur in the inverse, where he had the burglary conviction perhaps in Wyoming, applies for restoration, gets that back, then commits a crime of domestic violence, he'd still be a prohibited person under federal law, but he would not have his restoration of rights on the burglary repealed, that it wouldn't be void. It's only void, according to this, if he commits a new felony, correct?
Mr. Chairman, Co-Chairman, that is correct. It would be for a new felony.
Senator Case.
Mr. Chairman, about the discussion we had just a couple minutes ago about the Secretary of State's office and background checks. So the Secretary of State office doesn't do background checks on voters. When you register to vote, you sign an oath that you are, 18 years, U.S. citizen, resident of Wyoming and in the precinct. You have a valid Wyoming driver's license. You ascertain that you are not convicted of a felony, or if you have been convicted, that you had your rights restored. So that's your obligation to provide that. If later it's found that you signed this oath, there are two levels. There's a misdemeanor violation, but if you maliciously do it, it's actually a felony. So, but I don't want people to think that people are out there checking every voter to see if they have passed a background check. That's not the way it works. It's an affidavit.
Thank you. Appreciate the chairman of the Corporations Committee helping us out on that one. So, anything further for the director or the deputy director this morning? Final thoughts, Director Shannon, on this bill? And we may ask you a question as we work the bill, but any final thoughts?
No, Mr. Chairman, either. If we continue the way we're going, I believe there's a possibility that would jeopardize our citizens regarding felony convictions, which what we provide for now, as well as those who it's very similar to what Representative Jennings said. If a person is, let's say, from Nebraska and applies here, that's if we do nothing. If we go with Mr. Fuller's option 1 or 2, it makes no difference regarding my agency.
Mr. Chairman, go ahead.
Thank you, Mr. Chairman. So staff comment suggested that we consider the effective date being made effective immediately if we change, upon signature of the governor, if it passes in the next session. Does that work on the practical side on your end, or would you prefer a July 1 effective date that would give you some amount of time to amend things.
Mr. Chairman, Mr. Co-Chairman, thank you for the question and the opportunity to provide. I would change it tomorrow if we could regarding, so we don't keep giving out certificates that, and Mr. Co-Chairman, I would also like to respond when you asked about the certificate changing. We changed our website, we changed our application as well, as long as the letter that goes with it is really specifically says this is where you're risking, we advise you to speak with legal counsel and things of that nature. That's what we do at this time. If it was changed, the sooner, I think it would provide less exposure for those from this date forward until it would be changed.
Yeah, and I think the co-chairman's really hit on something that makes an awful lot of sense. You know, anything we can do on that certificate to help people understand, you know, once this goes through the process, that'll be great. So,
yes.
Committee, anything else? Thank you both.
Thank you.
I want to get anyone else up for testimony on this bill. 124 is the bill we're working draft .8. Do we have anybody online, Clarissa? Anyone else? Okay, we'll close testimony on 124.
Mr. Chairman, maybe just, if I may, I just wanted to respond to at least one of Representative Jennings' questions about what happens, you know, and this is specifically the context of firearms. You know, what happens if you get that new felony? You know, you have that language that says void. Mr. Chairman, state law expressly provides that upon a felony conviction, the court must advise that person of the loss of at least specifically firearm rights under federal law. And I think that's 711-507, I believe, that spells out that advisement must be given upon conviction.
Thank you for that, Mr. Fuller. Committee, go ahead, Representative Jennings.
Mr. Chairman, Mr. Fuller, so is that not allowed over the voting aspect of it also? Because there's a lot of federal law pertaining to that too. It seems like, I mean, that's why we got here, right? Was because we had people who were uninformed. They didn't understand what we were doing. And so is that available also to say same thing for voting rights?
Yeah, Mr. Chairman, Representative Jennings, I'd have to look a little more into that. I believe the statute, that specific statute only covers an advisement on firearms.
Committee, what's your pleasure on 124?
Move the bill.
Okay, moved by the co-chairman. Seconded by Representative Provenza, and by Senator Cooper, either one. So, discussion. Mr. Co-Chairman.
So my motion would be that we move forward with the version of the bill that is specifically for Wyoming convictions and not to include any other state.
Seconded by Senator Cooper. So discussion on the motion. Burns, thoughts? Representative Provenza.
Thank you, Mr. Chairman. I've kind of weighed back and forth on how I feel about this. I would like to extend the rights to other folks, but I think it comes at a great risk. So I'll be supporting that, but I just, I think it's unfortunate that the federal law makes it this way so that we can't extend rights back to anybody, regardless of where they committed. So I just wanted to share that sentiment because I think there's a lot of people that should have their rights back, should be able to hunt and possess a firearm in Wyoming despite making a mistake. But the federal law is in the way of us being able to uphold that value.
It's Representative, good thoughts. And, we might be in a position to work with our federal partners and take a look at something like that as we move on down the road. But I'm inclined to lean the same way. I think we would need help from our three back in the Beltway in order to probably go as far as we might like to go. But anyway, any other discussion on the bill? This is actually an amendment that we have on the floor here. So, Mr. Fuller, do you want to weigh in on do you understand what the co-chairman has?
So Mr. Chairman, yeah, my understanding is it's going to be the language beginning on page 2. So that would be the bill from which the committee would work. It would not be the staff comment that starts on page 10. So 2 through 10 would be the direction.
That is correct. So, committee, all in favor of that motion, please say aye. Aye. Any opposed, no? Okay, we will work 124 beginning on page 1. Let's go into the bill, make sure that we got it ready to go. Anything on page 1? Page 2, we have a staff comment. But I don't think that is anything to be concerned with. Representative Provenza.
Thank you, Mr. Chairman. Mr. Fuller, I may have misunderstood this, but in the second version, is that the only place we were able to restore like voting rights for people outside? Because the concern is the firearms, so.
Mr. Fuller?
So, Mr. Chairman, Representative Provenza, correct. The staff comment beginning on page 10, that version of the bill draft would provide for the restoration of voting rights for Wyoming or another state.
Anything else anything on page 2? Anything on page 3? Representative Harrelson.
Thank you, Mr. Chairman. So back when we kind of, do I have the liberty to kind of give a little bit of a very quick background and then give my amendment?
Sure.
Okay. So back when this came forward, as a pastor, restoration of rights is a huge thing for me because I work with individuals that have had a frustrating past or some problems in their past. And so whenever this came before us, I was very excited about it because I felt this was definitely a direction the state should be going, should have gone a long time ago, in my opinion. I would agree with my good representative from over the hill that I would love it if we could restore everyone's rights if they've chosen to make the right decisions, so to speak. But with that, whenever we had it wide enough to grab other states in the federal, one of the things that was brought in is on, and this is where the amendment comes in, on page 3, line 26 and 27, they put in the language, trust or profit within the state, or to use or knowingly possess any firearms. And at that point, we changed our statutes and added in some gun control into our statutes. And they said the reason we needed that is because of us addressing the federal and the other states. So my amendment would be to strike on page 3, line 26, or to use or knowingly, and then on to 27, possess any firearms. Because at that point, we're no longer having to address our state, other states and the federal. And this then opens it back up to just being, we can restore, but we're not putting that gun control language into our statutes. So that'd be my amendment.
Seconded by the no, I do not have a second. Do I have a second to that motion? Seconded by Representative Jennings. Mr. Co-Chairman.
Thank you. I'd be on and against the amendment. For all those folks who have nonviolent felony convictions but are not yet eligible for a restoration, right now, if they're apprehended by law enforcement or somebody who just hasn't applied to get their restoration, if they're apprehended by law enforcement, they're in possession of a firearm, their case is going to be referred to the federal government for prosecution as a federal gun felony. The language that exists here allows law enforcement the discretion to refer those cases to a state prosecutor for prosecution as a misdemeanor crime. I think we do those folks a disservice if we only leave law enforcement with the option of referring those cases to the United States Attorney for prosecution as a federal felony. I think it is much better for our gun owners who might incidentally be found to be in possession of a firearm, but they're not active criminals, otherwise, right, those sorts of folks. If we refer those cases for felony prosecutions by the feds, that's a big-time deal, and they would then never be eligible for a restoration of rights. So I'd be on and against the amendment. I appreciate the intent, but I'm against the amendment.
Representative Chesty.
Thank you, Mr. Chairman. I'm maybe confused here. It seems like the amendment is to a staff comment, and the staff comment is just information for us to evaluate the bill with. So nothing in this bill purports to amend section 6-10-106. So amending the staff comment doesn't actually amend that statute. So for that reason, I'm opposed to the amendment.
So, Mr. Fuller, can you confirm what the representative just pointed out?
Yeah, so Mr. Chairman, the staff comment's just for informational purposes. That said, I mean, it's certainly up to the committee to decide how to proceed.
And my apologies, I did not pick up on that, Representative. That is actually not a part of the bill that we're looking at today. So if the motion and the second are okay with that, we can take that up at a later time, or?
Yeah,
Okay.
I'm good with that. If we can take it
Good
up
to
at a
withdraw? Okay, so Representative Provenza, does that, you still have a comment?
Mr. Chairman, yeah, I was just going to respond to that before potentially the representative writes legislation to pull that out. I was sponsor on this bill, and part of what that federal law was that you had to take, like, you couldn't give something back that you hadn't taken away. So my fear would be if we do that, like, I understand your concern, and I had some of those concerns when we brought that bill, but I'd hate for us to say, like, I think we're going to fix this today. I think we're going to fix this. It's going to be great. Cool. Let's move on and, give people in Wyoming their rights back. If we kind of tinker with some of that stuff, that original stuff, we might be back in the same boat we were in before. And so I would just caution you on that, because I think we have the same goal and the same values here. So that would be my fear. Thank you.
Okay,
Mr. Chairman.
Thank you, Representative Harrelson.
Thank you, Mr. Chairman. No, I definitely agree, and we'll leave this and let this ship sail. And we can have that discussion later on and see if there's a better way of addressing it, if it needs to be addressed, and we'll talk about that. Thank you very much.
Yeah, I appreciate both you representatives. We're going to work this going forward. We've got a lot of good work ahead of us, and if there's a way to make this bill even better, I know we'll find it. The motion has been pulled, and we're back on the bill. Is there any other proposed amendments on the bill? I don't mean to go page by page. It's getting to be lunchtime. Is there anything else on the bill, committee? Representative Provenza.
Thank you, Mr. Chairman. I think we discussed that we would maybe want to change the law tomorrow if we could, so I would have this act effective immediately, and that's a motion to change section 3 on the date.
Second. And that's seconded by the co-chairman. And where exactly?
Page 10, section 10.
Oh,
Page
thank
10,
you.
line 22.
Page 10, line 22 is where we are. Thanks to my colleagues here for getting me acclimated. All in favor of the motion, say aye.
Aye.
Any opposed, no. That amendment has passed. That'll be effective immediately if we move this bill all the way through. Anything else, committee? Are we ready for a roll call? Okay. Roll call, Larissa, please. 124.
Mr. Chairman, this is a roll call vote for 25 LSO 124, Restoration of Rights Amendments as amended. Senator Case?
He left an aye vote.
Senator Cooper?
Aye.
Senator Furphy?
Aye.
Senator Schuler? Representative Chestick? Representative Crago? Representative Harrelson? Representative Jennings? Representative Nemec? Representative Oakley? Representative Provenza? Representative Rodriguez-Williams?
Aye.
Co-Chairman Washit?
Aye.
Chairman Landon?
Aye.
We have 14 ayes, Mr. Chairman.
Boy, that feels like a Senate bill to me. Committee, we have kept our good friends, our peace officers, quite a long time, and I'm sorry that we're running a little behind on the agenda, but I'm looking back, Mr. Thompson and others, wondering if we break for lunch, would that upset the apple cart, or would you prefer we push straight through? I'm good to ask the committee to keep going, or we can take a little break and come back.
Take a break.
Okay, thank you for your patience. We're gonna take a break, committee. Let's come back at 15 after 1, and we'll take up peace officer training after lunch.